All right, Malik Hatch. Hello. Hi.
Good morning, Your Honor.
Good morning. So on this case, it's my understanding he didn't get accepted into mental health court. And what I can tell you about that is that your acceptance into mental health court, if the district attorney, they have like veto power. And so there's nothing that can be done to place you in the program. I do, based upon the letters that was presented to me and the letters that was presented to the state, I think you would have been great for the program. I think the program would have been great for you.
Your Honor, just if I may, I am in talks with Daryl Harris about the Veterans Treatment Court.
Okay.
And Daniel Gutierrez. And so Mr. Harris is starting a trial today, so he said he couldn't give me a final answer right now. But he wanted me to send him some information, so I did that, and I'm waiting for his evaluation.
All right. So have you spoken with Herman?
John?
Yes.
Yes,
Okay.
but I haven't gotten a final answer yet.
Okay. Just give me 1 second.
So I'm so sorry.
All right, the court is calling 2025 CR 0000841. Everyone, please whisper. State versus Michael Keating. Can I have parties announced for the record?
Lauren Espinoza for the state.
Daniel Mailer for Mr. Keating.
All right, and are you Michael Keating?
Yes, ma'am.
All right, we're here. One, there's a motion to revoke on file, but also the defense has filed a motion to set bond. Defense, are you prepared to proceed on the motion to revoke?
I am not. I've not received any discovery at this time, Your Honor. I have requested it from the state, but I haven't received anything.
All right, Ms. Ferguson, on the motion to revoke, I need a contested hearing schedule in 15 days. Please give me the date.
Give me 1 second.
All right, so, and if you can give a reset form to Mr. Keating. Now, the next issue is the motion to set bond. He is on deferred adjudication, so he is still entitled to a bond. Is there an agreement on the bond amount?
I don't believe there's an agreement, Your Honor, but the state would be asking for a $60,000 bond.
All right, and defense, what are you requesting?
I would request $10,000, Your Honor.
All right, defense, do you have any witnesses?
We have no witnesses. I would, for the limited purpose of this hearing, call Mr. Keating.
All right. Can you raise your right hand to the best of your ability? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michael Keating,
All right, defense, you may proceed.
Mr. Keating, where do you reside?
Greenville.
It's correct that you also have a second residence in Canal County, is that correct?
Yes, sir.
And the court has previously ordered that you would be allowed to reside at both houses?
That's correct.
Okay. You work,
Travel, yes, sir.
but you're based here in San Antonio.
Yes, sir.
You have extensive connections to San Antonio.
Yes, sir.
Does this court have any concern whatsoever that you might not appear on the 20th as directed?
No, sir.
I have nothing further for Mr. Keating.
All right, so there was a question asked that I have allowed him to reside in any place other than Bexar County and Comal County. Is there some documentation of that?
I don't believe, just for clarification, I was only trying to establish that he has two houses and the court has previously allowed that he would be able to stay at either house. That's Comal County and Bexar County, nowhere else.
I mean, is there some document probation?
I believe it's in the court record, actually, Your Honor. That's where I read it on Odyssey.
I'm gonna need the file on that. Yes, ma'am. Did I allow Mr. Keating to reside in Bexar County and Comal County? Any questions, state?
Mr. Keating, do you ever travel outside the state for work?
Yes, ma'am.
Do you get permission from the court prior to doing that?
I did obtain that, yes, ma'am.
Thank you. No further questions.
Judge,
Yes.
you gave him permission to travel within the United States and internationally for work purposes only and have a secondary address.
Your Honor, if I may though, that secondary address on the order amending conditions was in Guadalupe County.
All right. And you're requesting 10,000, you're requesting 60,000? All right, Mr. Keating. Has there been any mental health issues in the past with you?
No, ma'am.
Have you ever been on any type of medications for mental health issues? Has there been any drug use in the past? All right. This is what the court is going to do. The court is going to set the bond at $20,000. The court is going to request partial GPS for employment only. Waive GPS fees. All right, is there anything else?
Just for clarification, so he'll GPS, but he's able to go to work.
Yes.
Thank you, Your Honor.
All right. Once you sign the reset form, counsel, and if you'll let your client sign the reset form, is there anything else?
Nothing from us, Your Honor.
All right, the record is closed.
Thank you.
Thank you.
Your Honor, I don't know why it's
Second.
still on the docket. You signed it.
Mantia, come down, please. Let me see what's in the,
He's incompetent, Judge. You're not gonna
Okay.
get
all
much
right,
out of
I'm
him.
trying to see what's in the
Okay.
Odyssey. Everybody have some patience. All right, Mr. Mantia, we're gonna recall you back and we're gonna recall you back late January. And the reason being is because you have a scheduled appointment in the criminal magistrate's court. So we're gonna call you back on January 19th.
Yeah, but ma'am, I have this paper, this is what I've been arrested for. And y'all got me for terroristic threats, and I've been booked for this. Two crimes, lawyer never even came to see me.
Okay.
It's
All right,
it's
Mr.
harassment of public servant,
Mhm.
and it says inmate death the property of conviction.
Oh, no, that's fine. All right, so Mr. Manita, let me explain something to you. So before anybody can proceed forward with my answering your questions about your cases, the first thing you'll have to see a doctor. And I'm going to see if they can expedite you before January 9th, but so far you're set for January 9th. And the reason why there's a gap in your setting is because we have a shortage of doctors who are available to interview. But I'll see if they can make it happen sooner rather than later. But we're going to bring you back here on January 19th. However, this is your attorney. And if everything is completed before then, your attorney will come in and we'll put you on the docket as soon as possible, okay? All right,
Thank you, Your Honor.
Thank you.
What I'm saying is, why am I being, what is my case for?
Oh, so you're charged, just one moment. I'll be able to tell you, okay? Just give me a second. You're charged with harassment of a public servant.
And he's got a misdemeanor, Your
And
Honor.
you also have a case that is not in this court. So those are issues that have to be addressed after January 6th, okay?
Thank you
All
very
right,
much.
thank you.
I was here on another case. I didn't know this was still on. I
Okay.
thought it was off. You'll send me email notice. Odyssey will. Thank you.
On Tuesday, you recalled Roger Blanco for today.
Mhm.
He's talking to Jonathan Alvarado about hiring him, but he has not paid Jonathan
Oh,
Alvarado.
so we are here.
Mr. Blanco was wondering if he could have more time.
Yeah, because this is an old case.
I hear you.
All right, thank
Okay.
you.
Thank you.
All right, Kevin Lawwill.
Got that part.
Why were you late before it?
I have no excuse, Judge. I was nervous and I went to the wrong courthouse.
We're gonna be ready.
What's this?
I mean, but you've been here before.
This one.
So this is a motion to withdraw and why? What's going on?
The only allegations are a new number 1 and a number 2 out of another county. And Lauren reached out to the other county to see if we could get anywhere on possibly trying to prove that up, and she was unsuccessful. Given that we've made an agreement to withdraw and alter and amend with some additional conditions
And what are these conditions?
to have him submit to IOP, supportive outpatient treatment, and monthly UAs based on the TAP evaluation and sober support meetings. In addition to a no contact order with an individual named Raul Sanchez, who was the person he was with when he picked up the new case in Victoria County.
All right, let's go on the record. The court is calling 2021 CR 4317, State versus Kevin Ray Lawwill. Can I have parties announced?
Melissa Albin for the state.
Tilden Schaefer from Mr. Law. Good morning.
And are you Mr. Lawwill?
Yes, ma'am.
All right, State, you filed a motion to withdraw, and it's the court's understanding that there is an issue with allegations that are in the motion from out of county,
That's correct, Your Honor.
and that the contact persons from out of county have no plans to appear.
Yes, that's correct, Your Honor. We've made attempts to reach out to them, but been unsuccessful.
And then, but to address those issues, and it's the court's understanding, the defense, you've agreed for the motion to be withdrawn, and in exchange for that withdrawal, you're requesting what?
We are requesting to alter and amend his conditions to include sober support meetings, monthly UAs, IOP, and a no contact order with an individual named Raul Sanchez.
That is correct, Your Honor.
All right. And Mr. Lawwell, can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Kevin Lawwell.
All right, Mr. Lawwell, do you understand the new conditions that are being added to your probation?
Yes, ma'am.
All right, and you intend to follow those conditions?
Yes, ma'am.
And so you're in agreement with IOP, the sober support meetings, monthly UAs, and no contact with Raul Sanchez?
Yes, ma'am.
All right, we can go off the record.
Judge, just so it's clear, I did explain what IOP is, it's intensive outpatient, so
Yes.
he knows what that means.
All right, thank you. All right, so Mr. Lawwell, you are on probation. And it's regular probation?
That's a good question, Judge. I believe it is.
All
Yeah.
right,
Yes, yes, sir. No, you lost that.
is it?
No, it's deferred still. It's still deferred. It is deferred.
So here's the thing, this is what you have to realize. You're on probation for deferred adjudication. What you're on probation for is a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison. Everything that you do, the people that you associate with, if those are people who are, for want of a better word, sort of shady, you shouldn't hang out with them because you'll pick up a motion to revoke. And you're looking at potentially 20 years in the prison. Do you understand?
Yes, ma'am.
All right, good luck to you. Once you sign the conditions, you're excused.
Thank you.
Thank
Thank
you.
you.
May be excused.
You too. All right, who's here on Cami Lumpkins? If you all could approach. In my understanding, this is an application.
Yes, ma'am.
Malik. Court is calling 2025 CR 010462, State versus Cami Lynn Lumpkins. Can I have parties announced?
Megan Galley for the state.
James Tochi for Ms. Lumpkins, Judge.
And are you Miss Lumpkins?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Lumpkins, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Lumpkins, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
No contest, Your Honor.
No. My question is, did you intend to give up those rights that I've just mentioned to you? Do you understand those rights?
Yes, ma'am.
Are you asking the court to allow you to enter into a plea bargain agreement with the state?
Yes.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge,
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Ms. Lunkins, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into this plea bargain agreement, you will be deported, denied re-entry and naturalization. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine. State recommends deferred adjudication. They will take in consideration 2025 PF 25148, 2025 AL 006849. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, ma'am.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 3 years. There'll be a TAP evaluation, 100 hours of community service restitution, no contact with
Ziamara.
Ziamara,
Perales.
XIOMARA Perales, life skills course, parenting classes, and prohibited possession of firearms. Did you understand those are recommendations from the state?
Yes,
And the
ma'am.
court does not have to follow those recommendations.
Yes, ma'am.
Then to the offenses charged, how do you plea?
No contest.
State any evidence?
States one and attachments.
Thank you. State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Just a couple of things, obviously, that the court follow the agreement. I don't believe Ms. Lumpkins has any history prior to this. She does have a minor dependent, Judge. I know that there's a fine, and I should have mentioned this earlier. She's not employed. She does care for the 3-year-old dependent. You could perhaps help her with her fine. And she took a parenting class already while in custody. Just wanted to make you aware of that.
All right. So you have a 3-year-old dependent?
Yes, ma'am.
And it-
I signed over my temporary rights to my mother as well as myself.
And it's, I'm assuming Child Protective Services is involved?
They were involved, but they closed the case as soon as I signed over the rest of my mother.
All right. So I'm telling you all, what's the child's name?
Roman Lumpkins, RHOMEN LUMPKINS. And his middle name is Connor, CONNER.
So it's Roman Connor Lumpkins? All right. So it appears to the court that the only reason why Child Protective Services is not in her life is because she signed over rights to her mom.
Yes.
So I'm not going to do this thing where you signed over your rights to your mom and then you go back and say, let me take my child back. Oh, well, I'm going to make sure that doesn't happen with conditions. So when's the last time you had employment?
Last time I had employment was about 6 months before I got incarcerated. I was donating plasma to help keeping my benefits and as well as giving my son clothes and shoes that he needs.
All right, what benefits?
EBT and Medicaid for him.
All right, so then you didn't have employment. What was your employment?
I let them know that I was just donating plasma and I would get $60 to $75.
Okay, technically, that's not employment. So when's the last time
6 months before I got incarcerated.
doing
So
what?
I was working at Bexar Fashions restaurant.
Okay. I always see that restaurant. I've never gone in and tried it because usually I'm passing by.
Kids eat free.
Yes, they do.
Oh, so you've been, okay.
Yes.
Well, let me bring out my pigtails. Going to school.
I only went to 10th grade.
All right, why?
I was never really involved with school. I was always just running around doing a little hoodlum. Instead of doing education, I was just running amok.
So what are your plans? Because you have a child.
My plan is to get a GED and show him that his mom can turn around her mistakes and better herself.
All right, so you're gonna have to reside somewhere other than your mom's.
I don't have anywhere else.
Well, here's the thing, I'm not, at this point in time, I can't trust you with your child at this point in time. I mean, it's a no-go for the court. This is what the court is gonna do. There's $1,000 fine. That will be probated. Court will sentence you to 4 years deferred adjudication. There's to be 100 hours of community service restitution. Ms. Abrams, the parenting classes at the jail is not going to count towards her parenting classes. Once parenting classes are completed, 50 hours will be deemed satisfied. The other 50 hours will be deemed satisfied if she obtains her GED. If for some reason you're unable to obtain your GED, then you're going to have to do those 50 hours. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be no unsupervised contact with minors. There's to be no residing in household with minors. There's to be no contact with Xiomara Perales. Course. Take into consideration 2025 PF 25148. 2025 AL 006849. The following will be done in custody. There should be a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, then follow TAP recommendations and field visits 1 time per month until further notice, or that can change if she's accepted in felony drug court because they will do their own field visits. I'm sorry, what?
How many months?
Until further notice. All right, Ms. Abrams, is there anything else? Oh, thank you. There's to be proof of employment within 45 days of release. There's to be no employment as a home healthcare provider or with minors. And what I can tell you, because you don't have custody of your child is not with you, so those benefits should stop for you.
Yes, ma'am.
Did you read the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. We can go off the record. Here's the thing. That 3-year-old can't even fend for themselves. That 3-year-old is 100% dependent upon you. And what did you do? You drove in a vehicle that was stolen with this Perales person. And then not only that, you all are doing drugs in the car. There's drugs in the car. And let me just tell you, meth stinks to high heaven. We had a case in this courtroom where someone brought in meth, and it took us forever to get that sent out of the courtroom. And you driving around with a 3-year-old impacting their brain cells with meth and marijuana in the car.
In my defense, she didn't let me know that the car was stolen. And
Here's the thing, there's no defense. There's no defense to driving around in a vehicle. And let's say you didn't know it was stolen. You had meth in your bag. she's driving away with drugs. You can't tell me that you don't know the people you hang around with. How long had you known her?
On and off for 8 years.
All right, so you've known her for 8 years. So number one, you know what type of person she is. You've known her for 8 years. And if you were to tell me it was a complete stranger, then I would be asking you, why are you getting in a vehicle with a complete stranger when you have a 3-year-old? If you want to put your life at risk, then go for it. But you're putting that child's life at risk by doing that. And signing over your rights to your mom, I already know that's the easy way out. And what ends up happening, people are in CPS court, and you know what they do? They sign their rights over to a relative. CPS gets out of their life, and then guess what they do? They go back to that relative, and then they have that child again. Not in this court. Good luck to you. Who's here on Beverly Zuniga?
Ready, Your Honor. James Seeloff.
All right, the court is calling 2022 CR 2568. Can I have parties announced for the record for the state?
Melissa Albin for the state.
James Seeloff for the defense.
And I'm so sorry. The style of the case is the state versus Beverly Marie Zuniga. And are you Beverly Marie Zuniga?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Beverly Marie Zuniga who was placed on community supervision in 2022 CR 2568 for the offense of assault family second offense on April 14th, 2022 for a term of 5 years? Is that you?
Yes.
All right, state.
We're going to proceed on number 38, Your Honor. In Bexar County, Texas, the defendant Beverly Marie Zuniga did then and there fail to report weekly for a period of 3 months as directed in violation of condition number 38.
How do you plead to that? True or not true?
True, yeah.
We'll waive the rest, Your Honor.
Any objections to the waiver?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 38, the court could find it true, grant the motion, sentence you to 5 years in the prison and a $1,500 fine? Knowing that, do you still wish to plead true to violation of condition 38?
Yes.
Court will find violation of condition number 38 true. Is there a proposed agreement?
There is not, Your Honor. I
We're
believe
going to open.
we are recommending revocation and the defense would like to ask for something else.
All right, defense.
If the court is going to revoke, we ask the court to do less than 5 years. She's currently taking medication for a heroin problem. And apparently she's doing quite well on that. She's got a couple of children, the youngest being 17. So I asked the court for a little mercy in this matter, and asked for credit for time served also.
All right, so probation, what has she done?
Your Honor, can we have just a few moments to step back and review the court summary?
Sure.
Thank you so much, Judge.
All right, so defense, it's my understanding from the state, they're recommending revocation. What are you requesting?
I'm asking you to, pardon?
The state's recommendation is to revoke and sentence for 5 years, TDC.
All right, and so what are you requesting?
I'm requesting less time than 5 years, 2 to 5. I'm asking, and I want to point out that she's 40 years old. She's taking a drug right now, a prescription drug to help with her heroin. She's doing very good on that. She has a couple of kids, the youngest being 17, and I asked the court for mercy.
All right, so is there anything you wish to say to the court?
If given the chance, would you go for?
Well, if she wants to
GED?
say anything,
Okay.
then she'll need to be sworn in.
Okay.
Oh, yeah, I was saying.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Beverly Marie Zuniga.
All right, and probation, she has pled true to violation of condition number 32. I'm sorry, 38, and the
30.
court has found that true. All right, what would you like to say?
I was letting my lawyer know that I was likely to get my GED because I didn't finish high school. And also my grandmother, she like relied on me. She has a pacemaker in her heart.
Mhm.
She's 87 years old. I don't have my parents. They passed away when I was very young. She's my only
So let me ask you this. If your grandmother is relying on you, why would you come to me? And this is your third motion to revoke. And let me just remind you, your first motion to revoke was a violation of condition number 2.
Yes.
The court denied the motion, alternate amend conditions to get you drug treatment. Then your next violation was a violation of number 4. The court alternate amended your conditions and continued you. And now you're back here for another motion to revoke. So why were you not thinking of your grandmother needing you before?
No, I have been, but I recently, I had a stroke myself.
Mhm.
And as you can see, my right hand is stayed messed up and I have this on my eye from when I fell. This happened in October. It's been like trying to take care of myself and take care of my grandmother. It's been really hard. And then with my kids, my daughter, she has lupus, the 17-year-old, she's in college, she just finished school. She doesn't have a father, she just has me.
All right. So this is what the court is going to do. The court is finding violation of condition number 38 true. The court is going to grant the motion. There should be no contact with Paula Pena. There's an affirmative finding of family violence. The court will give you credit for any time served, credit for any time served in inpatient treatment, and the court will sentence you to 5 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in community supervision. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Thank you, Counselor. Edward Valdez.
He's in custody, Good morning.
This is an old case. Is this a motion to revoke or is this?
No, this is just a setting, Your Honor.
It's a ninth setting. There's an application for PTD, Judge. We've resolved the case. So
Oh.
we're going to send that application in today. And he has an MTR in County Court 7. And I'm going to ask that he be held in 1.5 so we can resolve that also.
All right, I need a PTD date.
You can do that
I'm sorry, when?
November 6th.
Okay,
With the judge.
November 6th. So you need to make sure you follow through on that and everything is completed. Do you understand? And then, does he have a warrant for this case? Joel?
I think so, Judge. No,
Okay. All
he
right.
was remanded without bond on this case.
So does he have a warrant on this case or not? All right, y'all need to check because otherwise he's not going to be released. All right, thank you. Just
Yep.
have a seat. Okay. Nicholas Cornelius. We're going to go on the record in 2021 CR 0835 State versus Nicholas Cornelius. Can I have parties announced?
Aaron Espinoza for the state.
David McLean for the defense.
And are you Nicholas Cornelius?
Yes.
State you're asking that the motion be withdrawn?
Yes, Judge, we're asking it to be withdrawn and then alter and amended to add MRT and ISP.
We got no objection to that, Judge.
All right, and does he have a hold?
He has a federal hold, but he also is remanded without bond on the new case. I'm going to file a motion to get a bond on that. I know I need to file that before the court can rule on it. I discussed that with him this morning, just strategically how that was going to affect his federal stuff. But I'll get that filed with the court and we're going to request a bond on that case. I'm also working with the state. I'm hoping we can maybe get a disposition on that.
All right, because otherwise the new case. Oh, no, I see what the new case is. All right, and is there a reason for withdrawing the motion?
Your Honor, the state's position was that we are having issues with the new number 1, and then as for the number 2s, I guess I could have contemplated pleading on them, but I didn't.
Okay, all right. Then the court will sign the motion. The court will alternate amend conditions to include MRT and ISP. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Nicholas Cornelius.
All right, Mr. Cornelius, you understand that the state is requesting that this motion be withdrawn. Do you understand that?
Yes.
And we were set here today for a contested hearing.
Yes, ma'am.
Do you have any objections, counsel, to the motion being withdrawn?
No, Your Honor.
And Mr. Cornelius, they're asking that your conditions be altered and amended to include MRT and ISP. Do you understand?
Yes, ma'am.
And are you going to follow through with those conditions?
Yes, ma'am.
All right, is there anything else from either side?
Nothing further, Judge.
All right, we can close the record. laws have changed, so new things need to be placed up on the record. If you'll give that to
I got it.
Ms. Abrams, please.
Thank you.
Thank you.
Appreciate Just may I approach real quick?
Yes,
On Edward Valdez, there is no warrant.
okay.
Have a seat.
All right, thank you.
Thank you, Judge. Maybe excuse something?
Yes.
Thank you.
Court is calling 2025 CR 005795 State versus Linnell Trimble. Can I have parties announce? For the state,
Danny Callahan, defense.
and are you Mr. Trimble? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Am I pronouncing your first name correctly?
Yes, ma'am.
All right. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court's admonishments with your attorney, and did you understand it?
Yes, ma'am.
Did you understand you're charged with evading arrest, detention with the vehicle?
Yes.
That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights, and did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Trimble, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and denied reentry into the states. Do you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's an $800 fine and the state recommends deferred adjudication. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 100 hours of community service restitution, and the driving safety course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes,
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
no contest.
State any evidence.
Yes, Your Honor. State offer states Exhibit 1 in all attachments.
No objection.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments and review the same. After reviewing states Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I ask the court to follow the plea agreement, consider his youth, and that no one got hurt in this case, Your Honor.
How old are you?
21.
Why are you doing this?
I was testing a dirt bike that I had just visited.
Well, doesn't a dirt bike imply that it's supposed to be ridden on dirt?
Yeah, the person I was selling it to said he was gonna get it registered.
So it wasn't registered?
Oh, yeah.
And then that still doesn't explain why you didn't pull over when they asked you to pull over. If you would have pulled over, guess what? This would have just been a ticket. And now you have a felony. Are you employed?
Yes, ma'am.
Doing what?
Work at Northeast Baptist Hospital,
Okay, how far did you go in school?
graduated.
Do you have any children?
No, man,
And who supports you? Are you living with someone?
me and my girlfriend.
Does she have any children?
No.
All right, the court is going to sentence you to $800 fine. That will be probated. 3 years deferred adjudication. Proof of employment within 30 days. No employment as a home health care provider or with minors. Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person. Regular random UAs. 100 hours of community service restitution. I'm going to order the driver safety course. Once that's completed, the community service hours will be deemed satisfied. Probation, is there anything else?
Okay.
Is there anything else you need from the court in order to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. Know better, do better.
Yes, ma'am.
Thank you, Judge.
You're welcome. All right, so on this case. Hillary Veterans Treatment Court. You know, this is sort of like Star Wars with Princess Leia. Help me, Obi-Wan Kenobi. You're our only hope. So, yes.
So I had a good conversation with defense counsel. Ironically, as you know, Judge Darrell staffs the court and I staff it with him. So there's 2 of us who make the decision, so to speak. This particular case was reviewed by Darrell and he obviously made his decision, and the defense counsel and the staff actually have asked me if I'm willing to take a look at it
Yes.
and come to my own independent decision.
Yes.
And I told them I would. And so as of right now, I haven't read anything yet. I actually have an MTR on the 290th, about to happen at any moment. But I told them that I would. And so I'm going to go ahead and give them that, call it a review and kind of make what I anticipate to be the final decision, so to speak, Judge. I
So
haven't read any of it yet.
so let's do that by 1:30.
Assuming,
Oh, it can.
I don't know that I can do it, Judge.
Help me, Obi-Wan Kenobi. You're my only hope.
I don't know that I can do it. It depends on how quick my MTR with Ray Martinez goes.
Oh, it's gonna go quick.
I hope.
We're gonna
so.
say it goes
Are you
quick.
gonna call him?
No, I know it's gonna go quick. Because and the only reason why I say that is because everybody's in limbo with this.
I hear you.
So it's been trying to find placement for him.
I hear you.
So I know it can be done, Obi-Wan Kenobi.
I'll tell you what, Judge, if you said 2:30, I can do that.
All right, 2:30. Everyone, let's come back at 2:30 and this will be solved by 2:30. He will be on his way to Veterans Treatment Court and all will be right with the world. All right, thank you.
Thank you, Your Honor.
So I'll see y'all back at 2:30.
2:30, yes, ma'am.
Yes, thank you.
Thank you, Your Honor.
You're welcome. Chapa? All right, so what is happening with Mr. Chapa?
Yes, Your Honor. With regard to his matter, defense counsel is in receipt of new discovery. It was through the means of a portable drive. I was given access to, picked up this morning. So defense counsel is respectfully requesting time to review that discovery. Judge also did tender to the state an affidavit non-prosecution is uploaded in the Odyssey file system as well. I did request the state to look into the case regarding that, and I also simultaneously going to look at the discovery to make sure it's intact, Your Honor. If we could possibly, with the permission of the court, get this reset to November 6th for discovery pre-bargain deadline, Judge, it would be appreciated.
All right, Your plea deadline date then will be November 6th. All right,
Thank you.
thank you. You're welcome. All right, the court is calling 2024 CR 007456, State versus Gustavo Jimenez. Can I have parties announced?
In Galway for the state.
Renee Munoz on behalf of Mr. Jimenez.
And are you Mr. Jimenez?
Yes, ma'am.
All right, defense has filed a motion to set bond. The defendant is currently remanded without bond. State, have you had a chance to review the motion?
Judge, may I see it briefly?
Yes.
Here you go. Maybe you can hold on to that one. It might make tend to this. I brought an extra copy.
Thank you.
You.
Okay, yes, I've reviewed the motion, Your Honor.
All right, and State, are you prepared to proceed?
Yes, Your Honor.
All right, can someone tell me what is the reason he's remanded without bond?
So Judge, she was remanded because he was initially deemed incompetent and then referred to the Kerrville State Hospital for inpatient treatment. He was deemed restored by Kerrville State Hospital and then brought back here, which is where the remand without bond occurred. Looks like that's it's put into the system on July 3rd, 2025.
Okay, let me. And so the remand without bond though, was it just because he? Oh, wait a minute, I see what happened. He was incompetent. This is a violent offense. So
Alleged.
Alleged, yes,
Yeah.
alleged. I'm not taking this offense as true. So that is why, because the nature of the offense required inpatient treatment. And when they do that, they will remand. All right, now I know. I was trying to figure out whether or not you were remanded without bond because you didn't show up for court or something else. All right, is there an agreement on a bond amount?
Judge, that is my understanding of the reason why he was remanded without bond. There, we don't have an agreement, but I have no objection to the original bond amount being stated, which was 200,000.
Your Honor, we feel that amount is excessive. We're requesting a bond in a different amount than that, which is why we set that motion to set bond before the court, Judge.
Okay. And what bond amount are you requesting?
We're requesting 20,000, Your Honor, for a variety of reasons, namely because Mr. Jimenez was restored at Kerrville State Hospital. And if I may tender to the courts, the restoration packet.
Any objections?
No, I've had the chance to review, Your Honor.
And he was compliant with taking meds. He was compliant with staff there. In relation to his criminal history, this is the only violent charge that I can see him ever being alleged to have committed. So for those reasons, Judge, we believe that he needs mental health treatment. So he does not decompensate here in the jail. We're currently awaiting a sanity evaluation to take place, an evaluator. However, it's looking like that may take us into the new year, 2026. With my client being in custody and not having access to mental health resources, we don't want him to revert back to the state he was in potentially around this alleged offense. So that's why we're seeking to hopefully continue his care. I know that CHCS does have a FACT/ACT team for people with complex mental health needs. They offer psychiatric medication management, nursing services, primary care, peer support, as well as counseling. In looking to the restoration packets, I saw that was conducted at Kerrville, that he was engaging in counseling. He was consistent with his medication, and he was doing quite well, enough so that he was deemed restored to competency, Judge. For these reasons, we have filed the motion to set bond and requesting it to be set at 20,000. He doesn't have a lot of means, Your Honor. He's been in custody for approximately the last two and a half years since the alleged offense in 2024. His family members are all retired. His mother and father that he can live with are retired. But he does have that support system, and his brother is here as well, Mr. Vikky Lopez also, that can help take him to appointments as necessary with Center for Healthcare Services. So in light of the case, the procedure of the case, how it went along procedurally, and the fact that he was deemed incompetent, restored to competency, and now is seeking to maintain those mental health services that he needs, we feel like him at the jail is not going to have adequate access to those services, and we just would not want him to be compensated in that fashion.
All right, so the original bond was at $200,000. So somebody else set that bond at $200,000.
Correct.
The court will need more. Is there any other evidence that anyone wishes to present to the court as to why that bond should remain at $200,000, or why? I understand what you presented to the court as to why it should be lowered.
Right.
Yes, Judge, I would tender State's Exhibit B1 for the purposes of this hearing.
No objection, Your Honor.
All right. Then the court will accept into evidence State's Exhibit B1 for purposes of this hearing only. All right, counsel, is there anything else that's your motion?
Your Honor, if I may call a witness, my client's brother, Victor Lopez.
All right, Mr. Lopez. All right, could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Be sure to keep your voice up so the court reporter can hear. If you could state your name for the record.
Bexar Lopez.
All right, you may proceed.
Thank you, Your Honor. Mr. Lopez, how do you know Mr. Gustavo Jimenez?
My brother.
Is he your biological brother?
Yes, sir.
Okay. And do you guys have any other family here in San Antonio?
My mom and dad.
Okay. So your mom and dad currently do reside in Bexar County, correct?
Yes, sir.
Okay. Would if released on bond and subject to GPS full house arrest, would Gustavo be able to live at your mom and dad's house?
Yes, sir.
Okay. If needed to be taken to medical appointments, such as mental health appointments, would either you or your mom and dad be able to provide that transportation?
Yes, sir.
Okay. Would you also provide a support system in terms of making sure he's taking his medication as prescribed?
Yes, sir.
Okay. Now, you yourself, sir, are you currently working?
I'm retired.
Okay. Retired from where?
US Army.
Okay. How long were you in the Army for?
12 years.
Thank you for your service, sir. But you're currently not working, correct?
No.
Okay. To your knowledge, are your mom and dad working at this time?
They're retired also.
They're retired also. Okay. Also further to your knowledge, is Gustavo working at this time?
No.
Okay. Do you believe him to have any kind of significant adequate savings?
Yes.
Okay. You believe he has a lot of money in the bank to afford to a bond? Like, do you believe he has a lot of money to afford a potential high bond?
No.
Okay. You just misunderstood the question, right?
Yes.
Okay. I apologize. I'll try to slow it down a little bit. In terms of Gustavo, has he ever been violent with you or your family members before?
No.
Okay. Do you believe he has any other violent charges other than this alleged offense?
No.
Okay. Are you requesting the court set a reasonable bond so that he can get out to get mental health services?
Yes.
Do you believe he needs these mental health services?
Yes.
And you would do your best to support him in that regard, correct?
Yes, sir.
And how long have you and your family lived in Texas?
Over 20 years.
Okay. And specifically in San Antonio, how long?
18 years.
Okay. And that's here in Texas the last 18 years, more or less, correct?
Yes.
Okay. Do you guys have any other family anywhere located in Texas?
No.
Okay. Do you believe that Gustavo would be a flight risk, or that he would take off and not return to court if released on a bond?
No.
Do you believe he would follow all bond conditions, even if that includes mental health treatment?
Yes.
No further questions, Your Honor.
All right, you may proceed.
Briefly. Mr. Lopez, so currently, do you live with your parents or no?
No.
Okay, so in your parents' household, who all lives there?
My mom and dad only.
Okay, and at the time that this alleged offense occurred in April of 2024, was your brother living with your parents at that time?
No.
No? Where was he living?
On his own.
Okay. And you said that your family has lived in Texas for 20 years, is that correct?
Yes.
Okay, where did you all live before that?
Getting for her,
Colleen? Okay, and then was that due to military?
yes,
Okay, and before that, where did you all, your family live?
Puerto Rico,
Okay, do you all still have family members in Puerto Rico?
yes,
Okay, so the only family that you have here in Texas is you, your brother, and your parents, is that correct? But you do have a lot of family members in Puerto Rico?
yes, ma'am.
Okay, and regarding that, have you or your parents made any efforts to reach out to bonding companies to see exactly how much money it would take to post your brother's bond?
No.
Okay. And regarding, I know you said your brother has never been charged with a violent offense, but are you aware that he has a felony conviction for drug possession?
Yes.
Okay. And that was, do you recall what year that was from?
No.
Okay, but you are aware of that. Okay, we pass the witness, Your Honor.
Any further questions?
No, Your Honor, that's not.
All right, thank you so much for coming down. Any other witnesses?
No further witnesses from the defense, Judge.
All right, after hearing the evidence and reviewing all of the evidence was presented, the court will reinstate the previous bond that was set at $200,000. There's to be no contact with the following: thank you.
Thank you.
All right.
Your Honor, just for one thing, if released, would it be possible as a condition for the special needs unit coordinated with Center for
Yes.
Healthcare? Okay, great. Thank you, Your
And
Honor.
I'll add special needs unit with Center for Healthcare Services.
Thank you, Your Honor.
All right, thank you. And counsel, he is set on February 3rd. If
Yes.
y'all want to come back sooner, just let the court know.
I'll get with the magistrate's office, Judge, and see if they're ever to expedite the evaluation, and we'll update the court. If that's okay?
Yes.
Thank you.
All right, thank you. Who's here on Tiffany Martinez? All right, and this is for sentencing.
Yes, ma'am.
Court is calling 2024 CR 008238A, State versus Tiffany Martinez. Can I have parties announced?
Jim Wheat from Ms. Martinez.
And are you Miss Martinez?
Yes,
You entered a plea to count 2 of robbery. You entered a plea of guilty. Count 1 was waived without objection. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. The state is opposed to your application for community supervision or deferred adjudication, and there's to be restitution, if any, to the complainant. Have both parties had a chance to review the PSI report?
Judge, I'm reviewing right now.
Defense, have you reviewed?
Yes, Judge.
Any objections to the PSI report?
No, Judge.
All right. Defense, do you have any witnesses?
I'm just Ms. Martinez, but first I'd like the court to review a couple of letters of support that I've shown to the state.
Is this the supplemental?
No.
Have you had a chance to review the supplemental report?
Yes.
And I can tell both counsels, the court just saw the supplemental report, but the court has not reviewed the supplemental report. And is there any objection to the court reviewing the top evaluation and PSI report?
Not from.
No, Judge.
Okay, I've had a chance to review.
All right,
You need
the supplemental report, defense, do you have any objections to the court reviewing that?
No, Judge.
Okay. All right, and then defense, you said there was something else you would like the court to review?
Couple of letters of support. One is from her pastor at her church and the other is from her aunt.
All right, any objections to the court reviewing the letters? All
No, Your Honor.
right, just give me one moment. All right, state you're opposed.
Yes.
State, do you have witnesses?
No, Your Honor, just the evidence that was stipulated to.
All right, defense, any other witnesses?
Yes, we'd call Tiffany Martinez.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Tiffany Martinez.
All right, defense, you may proceed.
Thank you, Judge. Ms. Martinez, I want you to give the judge a little background on yourself and then also to talk about this incident that you've been charged with, right? Now let's start with sort of your childhood growing up. How was your childhood? How would you describe them?
So I was in CPS. I was abused as a kid. I didn't have the best relationship with my dad. And so I was just back and forth with my mom, my dad, my grandma.
How was your dad? How did your dad act towards you?
It was abusive. It
In-
was
In what ways? What else?
verbally abusive.
Okay. How long did that last?
Since I was maybe about 5 years old up until I got taken away, which was 14.
When you were taken away, where did you go?
Went with my mom to live with my mom.
Did you live with your mom the rest of the way through school? And was that part, at that time when you moved in with your mom, were things okay at that point?
Still trying to adjust.
What kind of adjustments were you making right then?
Trying to adjust to the new lifestyle, from being abused and I guess manipulated and stuff. And my mom's household wasn't like that, like my dad's. So I was still trying to adjust to the change.
And I know you're very nervous, but just take your time and we'll answer these questions and go through it. Was your mom more strict on you than your father?
She wanted the best for me. She wasn't mean to me like my dad. She didn't abuse me like my dad. She was hard on me academically and but she wasn't nothing like my dad.
Were you able to complete school?
I did, yes, early actually.
Where did you graduate from?
Southwest Academy.
After that, were you able to find a job and work?
I went to college, yes.
Okay. Where did you go to college?
Concord Career College,
And what did you get a degree in?
dental assistant.
And then after that, were you able to get a job and employment?
Yes, I did.
Where did you start working?
Right in dental and orthodontics.
Now, at some point in here, I know that you got married.
We were in the process, yes.
Okay. And who is your husband? His name?
Santos Hernandez, but we're not like officially
Okay. How long were you two together?
since I was 14 years old.
And along the way, did you have children with Santos?
I did, yes.
How many children?
I have 3.
How was your relationship with Santos?
It's good. I lived with him like at 17, I'll say. And we've been living together ever since. The relationship was always good.
Was there a point going back to 2022 and 2023 where you and Santos were not having a good relationship?
Yes, we were.
Okay. Why was that?
He was always gone, and our relationship kind of was fading as far as like there was no like affection or anything, and it was just kind of more like of a friendship at that point.
Were you working then?
I was, yes.
Where were you working?
I was still at, I was at Recess Dental.
Okay. And what were you were working as a dental assistant?
I was the lead dental assistant.
Okay. Now, during the course of that time period, that maybe 2021 through 2023, somewhere in that range, did you become acquainted with somebody named Roger Mims?
Did.
Okay, and how did you meet Roger?
Went to high school together.
And what kind of relationship did you have with Roger?
We were friends first, and then we pursued a relationship.
At that point, you were not with your husband. As you pursued the relationship, what kind of relationship developed with Roger?
It became very abusive, became manipulative. Very,
Okay,
not what it was, what I thought it would be.
when you say abusive, I know there's some very specific things that he did. Did he ever threaten you?
He did, yes.
How?
More than one time. He's went to my work multiple times. I had to hide in the dental ops. He chased me down Medina base with a knife, and then he told me he was gonna kill me. And then, there's just been multiple incidents where he's abused me, and because I tried to leave and he didn't let me.
Going all the way back to 2021, was there a time where he said he was gonna blow the head off your baby daddy?
Yes,
Was there a time in 2022 where he assaulted you and threatened your life? Was there a time in 2022 where he stole your wallet and car?
yes.
Okay, describe that for me.
I was working out at the gym. I had called in to work that day because he told me he was gonna go to my job and embarrass me and die my tires and mess up my car. So I called in and I told my manager what was going on, and I took the day off. And I went to the gym. I was working out, and then he comes in and enters, and I'm hiding in the men's restroom. I didn't want to go into the girls because I didn't like. I was just more safer in the men's restroom. He then still trespassed into the gym and he got me. And then the members were trying to help and they called the police. And then I was outside in the parking lot and he beat me up and he took my phone, my car keys, and my wallet. And he took off. And he took my house key.
Is there also a time in 2022 where he did flatten all your tires with a knife? Was there also a time in 2022 where he took a brick and busted out the driver's window on your car? How did that happen?
Said before, I couldn't never leave him, and every time I tried to, he would just threaten me and he would actually do whatever he said he was gonna do. And so we lived close to each other and he just followed, he got a break, he followed me and he busted my windows and I had just gotten that vehicle.
Now, were there numerous other incidents with Mr. Mims?
Yes,
Were you aware that he had a long criminal history?
I did,
You do know that now after we've talked about your case?
yes.
Now, going to the time of this incident, were you still with Roger?
We were not together, but I felt like I was just had not so much of a relationship, but the communication for my safety, because he said that if I don't talk to him, that he's gonna still do all these things that he was doing to me. So we were still communicating, but we were not together.
So on the day of this incident, how did you come to be with Roger?
I picked him up. Went to his house. We were just talking about like everything that was going on, and as far as like my relationship with Santos, and Santos was supposed to be watching the kids that night. He wasn't, so I vented to him.
At this point in your life, were you drinking
It was
more than you should?
more than I should.
And were you using any drugs?
So,
None at all, not marijuana? Now, how did the drinking affect you?
It affected me because it became a bad habit. It was every day. I used it to numb from everything that I was going through in my life. And it was just, yeah, it was not a good habit.
Now, as far as this incident, the day this happened, how did it come up that this happened?
So I was with my friends that night. And like I said, Santos was supposed to be watching the kids at the house. We would take turns. And so I decided to come home early. It was like 10:30. And I noticed he wasn't there. So I was upset because I was like, okay, well, where are the kids? But they were with my grandma, and my grandma also lives at the house. So I picked up Roger, and I was just freaking out because, like, obviously, like I still had feelings for Santos, but we were not together.
Okay, how do we get to the point of this
This-
offense? Yes.
So Santos came home, and then another car pulled at the same time. So that vehicle was, I assumed, his girlfriend. So I followed her with Roger, and that's how we,
All right, so you thought this was his girlfriend.
yes.
So did you say, hey, Rogers, that's your girlfriend, let's follow her?
No, it was Santos.
Santos, did you
Yes.
say, hey, Santos, that's your girlfriend, I know that's your girlfriend, we're gonna follow her?
No, so Santos was already in the house. Santos pulled up the same time that other car did. So Santos was already inside. I was with Roger outside of my house. And we both saw the vehicle, and Roger's like, follow her, like, go, let's go. And I'm like, okay, well, let's go. And we followed her, and
And then what happened?
we got off the vehicle, and I had told her, excuse my language.
Oh, no problem, I've heard it all.
Okay, I said I used Santos's bitch, and she was just like, who, like he, and then she swung on me first, and I was like, okay, well, we're gonna obviously fight. So we began fighting, and then, we just fought, but
Where did the gun come from?
I didn't know there was a gun until there was like 3 sessions of fights, and we tried to break it up. And then on the third time, that's when Roger pulled out the gun and said, I'm gonna kill both of you bitches. And he shot towards us. Well, he not towards us, but like, I don't know if it was up in the air or towards us or what, but it was shot. And then we both let go of each other, and then we just got up and we left. And I grabbed her phone thinking it was my phone. And that's where the robbery came in.
Now, the police talked to you afterwards, right?
Yeah.
And you admitted to all of this stuff that you told the judge?
Yeah.
Admitted to the robbery at that point?
Yes,
Are you still here today to tell the judge that you know this was wrong?
it is wrong, yes.
Now, from this offense, from what you've pled guilty to, how have you lived your life since then?
I stopped drinking. No longer have contact with Roger, and a lot of my friends that I had, I don't talk to anybody anymore. Try to do community work for the church that I go to, and I help them. And change my life, even though like I'm in the situation that I am in. I still try to look for the best of it.
Okay. Over the course of the last, it's been more than 2 years, I believe.
Yes.
Have you had anything to drink?
In the beginning, yes, like fresh after the case, yes. But no, I don't drink
How did you stop?
because I was tired,
Tired of what?
tired of drinking. I just wanted better for myself, and I didn't want to drink anymore. I was tired.
Have you using any drug?
No.
Okay. And since your release, you've been on the monitor the entire time?
All 2 years, yes.
If the judge were to give you a probation, a deferred probation that we're asking her for, what would be your next steps as far as seeking employment or handling things with your kids?
I would reapply for my dental license and I would try to go back to the dental field. I did do a lot of years in there, so I would try to do that and get back on my feet.
Where are you living right now?
What is on those?
And are you both taking care of the kids?
We do this, mainly me, because he works and I can't work at the moment. It's been hard. So it's mainly me.
Now you have some family here in the audience. Can
I
y'all
do.
stand up, please? Family in the audience? And who's here for you?
So I have my mom and I have Luis, which is my brother-in-law.
That's Santos's brother.
It is, yes.
They're both here in support and would like for the judge to consider probation for them, right? Is there anything else you want to tell the judge or explain about this happening or about your background in any way?
Yes.
Okay.
I don't know if Bianca is here or if she's listening, but I am very sorry. I have prayed for her mentally and physically, and you know, I am sorry. It was 2.5 years ago, but it doesn't matter how long it was, it still was done, and I do take responsibility for it. And I do plan on, if everything goes good, I do plan on getting back on my feet, going back to work and continuing my life, because I did lose everything. Lost my car that night, the same night. I lost my job, I lost my freedom, I've lost money, I lost just literally everything within the 2 years. So from having everything to literally nothing, starting fresh, it's been hard mentally too. And I was on full house arrest where I couldn't even go to work to one point. So it was hard to adjust from having everything to nothing, from everything being taken away from you because of your own decision from my own decision that I made. And I'm fully aware of that. And also for my children, because, you know, I wasn't at the right mindset at the time. I do know now, and I mean, it should not have taken me this long to realize, but I did come to a realization, and, you know, I love my kids and I would hate to be gone away from them that long. And I felt like at the time I was keeping them safe and pursuing this relationship, because no matter what I did, he was always there, no matter if I wanted to leave or not. Like, I just felt like I didn't have any help. I mean, just to leave, like I was being threatened, I was being abused, like couldn't find a way out.
And are you still with him?
I'm not with him, no. So in a sense, I don't know if this is bad to say, but I'm kind of glad this happened, because it's not happening anymore with him. So I'm free from him, not free from you guys, but I'm free from him. So I just want to be at home with my kids. My kids are just getting older. You know, I've missed baby showers, weddings, I missed parties just because of being on house arrest, and it's been tough. It really has, and I've changed my life. I'm not half the woman I used to be. Was a girl, I'm a woman now, and I hope we take into consideration my children. They do need their mom, and you know, and I just want to tell Bianca, like, I have been brave for her, and I'm sorry, and I hope we're able to get past this. It's, you know, I've been waiting for this for 2 years, 2.5 years, so I'm ready.
All right. State any questions?
Yes, Your Honor. Okay, Ms. Martinez, so you have 3 kids, is
I
that
do.
correct?
Yes, ma'am.
Okay, what are their ages?
I have, like, I see.
You can, yeah.
Okay. I have a 5-year-old, an 8-year-old, and a 9-year-old.
Okay, and so it's your testimony that on the date that this offense occurred, that you had left them with Santos so you could go out with your friends, is that correct?
Yes.
Okay, where were you and your friends at before the offense occurred?
We were down the street. We all live pretty close. So
Okay.
my friend had like a little, we just get together, some drinks and, you know, just to hang out.
Okay, and then you go back to Santos' house
Mhm.
at around 10:30, is that what you said?
10:30, yes.
Okay, so I'm kind of confused on the timeline of your relationship. I'm hoping you can give me some clarity. So you testified that you and Santos began your relationship with each other when you were 14 years old, is that correct? Okay, and about what year was that? Do you remember?
2012.
Okay, and then you guys
break up when you're in 2021. Okay.
Yes.
But in 2021, you all are still living
still living
together.
together, yes.
Okay, and you're stating that you still had feelings for him at this time,
Yes.
correct? Okay, and so then you break up with or you and Santos break up in 2021, and then you meet Roger Mims in
Mhm.
2020.
Like around there, 2021, like.
Okay, I'm sorry. Could you speak up so I could hear?
Yes,
Yeah.
okay.
It's okay.
Yes, so we did meet, around 2021, maybe the end of 2021.
Okay. And so you did testify about the incidents that occurred with Roger Mims. And in fact, it got so bad that you even got a protective order against him in 2022. Is that correct?
Yes, I did.
And so that protective order was still in place when you decided to call him up in 2023 on the date of this offense, right?
Yes.
So while you had a protective order, you were still communicating with Roger Mims, correct?
Yes.
Okay. And so when we're talking about the night of the offense, you stated that you picked Roger up from his home, correct?
Yes.
Okay. Well, I guess let me back up. So you arrive at Santos' house at around 10:30, is that correct?
Yes.
Okay, and then you see that Santos is not at his house, correct?
Yes.
And so then you decide to call up Roger Mims, is that correct?
It is correct.
Okay, and then you go to Roger Mims' house to pick him up, correct?
Yes.
And then you drive back to Santos' house, correct?
Yes.
And then at that time, you see that Santos is now back home, correct?
Yes.
And there's a white motor vehicle that's parked across the street, correct?
Yes.
And so you and Roger decide at that point, and I think when the detective spoke with you about this, you told the detective that you saw the white car outside and thought that it was Santos's bitch, correct?
Yes.
Okay, and so after thinking that, knowing that you still have feelings for Santos, but you're still commingling with Roger, you all decide to follow that white motor vehicle, correct?
Yes.
Okay, and so that white motor vehicle pulls up to a home, correct?
Yes.
And then you were in the driver's seat, correct?
I was driving. Yes.
Okay, and Roger Mims was in the passenger seat, correct?
Yes.
Where was the firearm during this time?
I don't know where he had it because I wasn't aware he had one.
Okay, but it was in the car with you, correct?
Yes.
Okay, and so you exit your driver's seat, correct?
Yes.
And at the time that you approach Bianca, she's in her front yard, correct?
Yes.
Okay, and so it's your testimony that she swung on you first, but would it surprise you to say that she didn't? Would it surprise you that she says that she did not hit you first?
She could say what she wants, but I mean.
Okay, but notwithstanding that, you were on her property, correct?
Yes.
And you guys enlisted in a fight, a fist fight, correct?
Yes, ma'am.
And that fist fight left her with injuries, correct?
Yes.
Her lip was busted, correct?
Yes.
She had scrapes on her knees, correct?
Yes.
And it got so rambunctious that there was flip-flops spread across her front yard, correct?
I'm not too sure about that.
Okay, and then the fight spills over into the street, is that correct?
Yes.
And I'm sure that you've reviewed the discovery, but there's a Ring doorbell camera that was turned over from a
Yes.
neighbor, correct?
Yes.
And in that Ring doorbell camera, you can hear Bianca saying, "Please stop." Do you recall that?
Yes.
Did you stop when she asked you to?
She wasn't telling me to stop. She was telling the other person.
And who's the other person?
Roger.
Okay, and what was he doing at that time?
Oh, you know what he was doing?
Was he curb stomping her at the time, or did he have the
Uh,
firearm out at the time?
I think he was curb stomping her.
Okay.
Cause I was already in my car.
Okay, and then after that, you all get back into the motor vehicle, you get back into the driver's seat, correct?
Yes.
Okay, and Roger gets back into the passenger seat, correct?
Yes.
And at this time, you have Bianca's purse and her cell phone, correct?
I only have her cell phone.
Okay, but at one time, you or Roger had possession of her purse, correct?
Correct.
Okay, and regarding the cell phone, you stated when you were speaking with your attorney that you believed that it was your phone, is that
Yes.
correct?
Yes.
Okay, and do you recall when the detective went to Santos' house to speak with you?
Yes.
Okay, and do you recall telling the detective that you took Bianca's phone and bag and then gave it back to her
but then she took a picture of your license plate and then you took the phone again. Do you recall that?
No.
Okay, well, would it surprise you if that's contained on the detective's body worn camera?
Yeah, because I am the one who told him where her phone was.
Okay, well, let's get to that. All right,
Okay.
so then after Roger points the firearm at Bianca, do you recall that?
No, I didn't see him point anything. I just heard it.
Okay, you heard him discharge the firearm.
Yes,
right?
yes,
Okay, and then you all enter your motor vehicle and drive off, correct?
yes.
Okay, and
Steve, can I speak? Can I say something?
go ahead.
So it wasn't just at Bianca, it was also at me too. We were both in the street.
Okay,
So the firearm was toward both of us.
that's fair. But moving on, you all flee the scene, correct?
Yes,
And you toss the cell phone knowing that it belongs to Bianca, right?
no, so we got into an accident right literally after that because Roger, he pressed my foot down and we hit another vehicle. So he's like getting the phone and at that time I knew that it was a gun because obviously it went off. He threw the gun and the cell phone, so I don't know where it was, but I told the officer where the accident occurred and the area that we hit the other vehicle, so that's how the officer recovered it.
Okay, that is correct. So the cell phone was recovered in the
Okay.
area of the crash.
Yes.
Okay, now I want to talk to you about the crash because
Okay.
it was a pretty serious crash, right?
Yes,
And you were driving the vehicle, correct?
Yes,
And he was in the passenger seat, right?
yes,
And so it was so serious that the police had to be dispatched, right?
yes.
Okay, and you're aware that those police officers had body worn cameras,
I
right?
do, yes.
Okay, and so you remember that after the crash occurred, Roger's hugging on you and kissing on you and filling on your buttocks after you all just committed this offense. Do you recall that, right?
I don't know.
You don't? Okay, but if it's on the body worn camera, that's not fabricated, is it?
If it's on the body camera, no, it's not, but I don't recall that.
All
We
right.
literally just got into an accident, so
Okay,
we're
that's
both
fair.
hurting.
And so when Roger was arrested for this offense, you were still communicating with him while he was in the Bear County Jail, correct?
When he was arrested, he didn't call me from jail or anything. I didn't know he got arrested until he didn't get arrested for like a whole year later.
Mhm. And so it's your testimony that he didn't call you from Bear County Jail?
Not that I recall, no.
Okay.
I would get text messages from him, like text now or like fake phone numbers because his number was blocked, but I don't remember getting a call from him from jail, no.
Okay. And so you've told this court that it's been hard for you to adjust from being on ankle monitor. And I do appreciate that you realize that that's all because of the personal decisions that you made.
Yes, ma'am.
But I want to ask you, Judge, may I see that supplemental report? That, would it surprise you to know that Bianca states that she has lost a sense of peace that she once had since
Judge,
this offense?
We're going to object to this line of questioning. It's not proper impeachment. And the judge, you have the facts and the statement right before you.
All right, the objection will be overruled. You may ask your next question.
Okay, so I'm gonna ask you, you have told this court that it's been hard for you to adjust. You understand that it's been hard for Bianca to adjust from this offense occurring against her, correct?
Yes.
And do you think that's fair that she has to deal with those things and go to therapy and relive this? Do you think that's fair?
No, it's not.
Okay, we pass the witness around.
All right, any follow-up questions?
No further questions, Judge.
All right, this is what the court will do. After reviewing everything and hearing the testimony, the court will find you guilty. The court will sentence you to a $2,000 fine. Time and money will run concurrently. 6 years in the prison, give you credit for any time served. There's restitution of $940 to Gonzalez. The court will order the removal of the GPS. And there's also to be no contact with Roger Mims. And Santos Hernandez. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
This document that we signed for us.
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And counsel, I'll request the therapeutic community to address any issues. All right, is there anything else?
No, Judge.
All right, thank you. Good luck to you. Kira Kilson. All right, and what are we here for?
This case was old. Miss Gilson got picked up again, so I think it was set for a status or trial conference. We conferred with the state. I think we're just asking for the case to be recalled next week,
Yes.
and we may have a disposition at that time.
All right. Norma, we need a date for next week for disposition.
Monday, 13th.
All right, so we'll bring you back on the 13th.
Okay, thank you, Judge.
Thank you, Judge.
You're welcome. Veronica Callahan. All right. What is happening with this case?
This was previously set for maybe a plea deadline. I was here, Miss Callahan wasn't. I approached the court. She had a medical issue. The court said to, issued a judge's warrant and would reconsider that when Miss Callahan reappeared in front of you. So we're here today. She did pick up a new offense. Miss Rochelle Acevedo's on that offense. It's a pre-filed case. We did get an offer today. Not ready to accept that offer.
We'll recall her back for Monday.
Okay.
All right, we'll recall you back for Monday for a disposition. If disposition does not occur, then your next setting is going to be a jury trial.
And Judge, on the warrant issue, would the court consider that?
Did she provide medical proof?
I wasn't, yes, she had gave me a notice. I apologize for not printing it. I was aware of Miss Kilson's setting.
Then I'll take that up on the 13th.
On the 13th. Okay.
Thank you. All right, this is Jonathan Lozada.
Gardo, yes, Judge.
All right, the court is calling 2025 CR 012153 State versus Jonathan Lozada. Can I have parties announced?
Ashley Jones for the state.
And Jason Wolf for defense.
And are you Mr. Lozada?
Yes, ma'am.
All right, it's the court's understanding that this is a motion to amend conditions of bond, not to reduce bond. Is that correct?
Correct, Judge.
And it appears that you all have agreed that he is excluded from entering Kirby, Texas. And he's to stay 200 yards away from Wagner High School. And is this Hopkins?
It is, Your Honor.
Hopkins Elementary. All other bond conditions remain in place. Are you all agreeing on this Monday through Saturday, 6 a.m. to 6 p.m.?
Yes, Your Honor, with the below stipulations.
All right.
Yes, Your Honor. He has his stepfather here who he'll be working with during those hours and those homes that will be new construction homes, that will be empty homes, vacant homes.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right. You can lower your hand, state your name for the record.
Jonathan Gardo.
All right. You're employed.
At the moment, I
What?
with my father.
All right.
If possible.
So parties have reached the following agreement, and I need to make sure that you understand it, because if you violate this, then there will probably be a warrant for your arrest. Do you understand?
Yes, sir.
So according to this, you're allowed to leave your residence Monday through Saturday from 6 a.m. to 6 p.m. That's for employment only. So you're not allowed to stop on your way at different locations. It's strictly for employment. Do you understand? Now, even though you have that agreement where you will be able to work, you're not allowed to enter into Kirby, Texas. Do you understand? Don't make any mistake, because my understanding Kirby, Texas is landlocked and it's right on the border of their county. You are to stay 200 yards away from Wagner High School and Hopkins Elementary. Do you understand?
Yes.
It's probably best that you just do not even go on that street. Do you understand? All right. Is there anything else from either side?
No, Your Honor.
Right.
State.
And when is he set in this court?
The judge, he was just transferred to this court, recently indicted. We had a hearing that was set in Green Mountain Court. Now the court is taking care of that hearing, so I'm not sure when the next settlement.
Right, so we need to get a setting for him and it will be a discovery setting. Ms. Ferguson, I need a 30-day reset for discovery.
Let me make sure that it's not set already.
Okay. And if it's already set, he needs a reset form. All right, so you'll be back on November 10th. Court is at 9 a.m. and state, I'll need you to be prepared to tender and offer that time. And are there any CPS records? Do we know?
I think we should be inquiring about those, Judge.
Yes, Your Honor. From my recollection, I apologize, I looked at a couple different cases. We do have those in already. There's also a flash drive with several,
All right, so if you'll give me the
phone
protective order
instructions.
before you leave today so that he can have access to that.
Will do,
And
Judge.
then counsel, if for some reason the state is not able to tender and offer, of course, your plea deadline date will be further out.
Okay, thank you,
Most
Judge.
likely in the new year. We
Thanks.
shall see.
Thank you, Judge.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you.
All right, Roger Blanco. All right, so you're gonna be called back on October 14th for jury trial.
No, Judge.
There's paperwork, okay. All right, the court is calling 2025 CR 002-804 State versus Roger Luis Blanco. Could I have parties announced?
Lauren Espinoza for the state.
Michael DeLeon for Mr. Blanco.
And are you Mr. Blanco? Counsel, you received all discovery. Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Is there an application in this case?
No, Your Honor.
Mr. Blanco, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the enhancement allegation.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with evading arrest, detention with a vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Do you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe he's mentally competent.
Mr. Blanco, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
That is what it is.
All right. Did you understand by entering this plea, if you're not a United States citizen, you will be deported, denied naturalization, and not allowed re-entry? Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 6 years in the prison. There's a $1,000 fine and no applications. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No motions, Your Honor.
Then to the offenses charged, how do you plead?
No contest.
State, any evidence?
Yes, Your Honor, state offers states exhibit 1 and all attachments.
We've reviewed that, Your Honor. No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence the court to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
The court will follow your agreement, sentence you to 6 years in prison, give you credit for any time served. There's $1,000 fine. Time and money will run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Based upon the indictment, you know what your minimum was?
A lot more than that.
25 years. So for you to say you are not satisfied with your attorney, your minimum, you were starting at 25 years, and he ended up was able to negotiate 6 years for you. So you understand? You are a habitual, and that means anytime there is a felony that's a 3rd degree or higher, your minimum is 25 years. That's where you start at. And if you would have gone to a jury trial and a jury were to have found you guilty of this, and then they found the enhancements true, your minimum is 25. You're not eligible for probation from a jury. If you were to gone to a jury trial and then found guilty and then came to me for punishment after being found guilty, if the enhancements were proven true, your minimum is 25 for me. You understand? So you're going to have to start making better choices. I don't know what was in your vehicle. I don't know what was going on. But if you would have just pulled over, you know what you would have ended up with? A traffic ticket. All right. So your attorney did a great job for you.
Thank you.
All right. Good luck to you. All right. Mr. Adape, are you here for Jessica Heron?
No, Your Honor, I'm here for the 2 motions to withdraw from Michael Joseph Mora, and I also have Jesse Diaz.
All right. Michael Joseph Mora, come forward. All right. Your attorney has filed a motion to withdraw. Are you aware of that? And counsel, I don't have the motion. All right. Mr. Adape, I see your reason for withdrawing from Mr. Mora's cases.
Yes, Your Honor.
So though that will be granted in cause number 2023 CR 4008 and 2024 CR 4073.
Thank you, Your Honor.
And you were appointed, that's correct?
Yes, Your Honor.
All right, thank you. All right, sir, just have a seat. We are going to get an attorney for you.
Okay,
Thank you. All right, Mr. Adape, who else do you have?
Your Honor, I have Jesse Diaz, 2025 CR 10356.
103. I'm on page 3, 4 down. And is that Jesse Diaz? Come forward. And is this a motion to withdraw?
No, this is just the first discovery setting, Your Honor. I had sent a message to the phone number that was on the appointment, and I hadn't heard a response.
All right, sir. Ms. Ferguson is going to be able to give you your attorney's phone number. You need to make sure you stay in contact with your attorney. Do you understand?
Yes, well, I called him on long, maybe about like 6, well, yeah, maybe about 6 to 8 months, I think it was, and that was the last time we talked.
All right, so she is going to give you his number, and he's going to be in court for your next setting, all right?
Okay, miss.
All right, Ms. Ferguson, I need a setting in 20 days for this. October 30th. All right, so we're going to be back on October 30th. Your attorney will be present in court, all right?
Okay, miss.
All right, just sign the reset form, then you're excused.
Thank you.
Thank you, Your Honor. May I be excused, Judge?
Yes.
Take care.
Joshua Mackey. All right, the court is calling 2024 CR 5495 State versus Joshua Mackey. Can I have parties announced for the record?
Rick Payne for the state of Texas, but I believe it should be 2014.
Okay, so here's the thing. Y'all need to slow it down because the court reporter has to take everything down, and everyone is going to have to raise your voice.
Rick Payne for the state of Texas.
For the
Kelly Piddle for Joshua Mackey.
And are you Joshua Mackey?
That's for me.
All right, and let me see here. And is the date on the motion to revoke, what is the date you all have for when it was filed?
There's two, Your Honor. The original motion to adjudication of guilt was from February of 2025.
Just one moment. Probation, can I have a copy of the motions to revoke?
Yes.
Because I don't have the right filing date.
While I don't know if the one that you do have though is state supplemental motion, which was from March of this year.
I don't have any of that.
Okay.
All right, are you the same Joshua Mackey who was placed on deferred adjudication in 2014 CR 5495 for the offense of aggravated assault with a deadly weapon on April 6, 2015 for a period of 10 years? Is that you? And have you had a chance to review the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney? These documents, have you reviewed those?
We've reviewed each, right? Yeah, changes reasons. Institutions.
All right, have you had a chance to review those with your attorney?
Yes,
You need to
ma'am.
say yes or no.
Yes, ma'am.
All right, do you understand them? All right, state.
Before we continue, Your Honor, maybe go off record for 1 second.
Sure.
If we're going to proceed with a contested, one of our witnesses is a Harris County probation officer who is on the Zoom. I want to make sure that defense is okay with us proceeding that way.
We're gonna object. Under the Sixth Amendment and due process.
They say they're going to object to your witness appearing by Zoom.
In that case, Your Honor, we would ask for a recess so we can have her available to come and drive in to testify in person.
All right, just one moment. And who is this? Is it Jessica Hera?
Yes, Your Honor.
Can I respond?
Yes.
We were set on this case last Monday when the court said it very contested.
Mhm.
It's my understanding, and the state can correct me if I'm wrong, they subpoenaed the witness sometime this morning between 10 and 11 a.m. Knowing that we were set for the contested this morning, we ask that you deny their continuance.
All right, the court will recall this case, court will recall it for 3:30.
Okay, may I, okay, 3:30.
All right, so, Officer Heron, we'll need you in Bear County. The defense has objected to your appearance by Zoom. So I'll need you here by 3:30.
I'm in Harris County.
And is that Houston?
Yes, ma'am.
All right, so what is the drive time from Houston to here?
Uh,
4 hours.
All right, so, we'll have you here then by 4:30. Is that possible?
I have to see because I have to pick up my son from daycare as well.
All right, just let us know.
Yes, ma'am.
If it doesn't work out, Your Honor, can we get it reset until Monday?
No.
Let's see where we are at this afternoon. So everyone is to come back in the afternoon.
Okay. What time, Judge?
Let's say 4:30. I don't know what the issues are in Houston. And Officer Heron, if for
Yes,
some-
ma'am.
you're able to be here well before then.
I have to speak with the supervisor about it because I didn't know I was gonna be needed in Bear County.
Okay, all right, I'll probation, I'm sorry, the state and the defense will be able to speak with you probably, all right?
Yes, ma'am.
All right, and they'll let me know something. All right, thank
Can
you.
you ask her if she comes? I want her to bring her complete file.
We do have the probation officer in their county here. Is there any way that we can proceed with her testimony so that?
Yes,
We can get her out of the way, yes. and come back
Yes.
for hers.
so he needs to go on the record on whether he's pleading true or not true. All right, thank you so much, Officer Heron.
No problem.
All right, you may proceed.
Yes, Your Honor. Violation condition number 5, in Bear County, Texas, the defendant, Joshua Mackay, did then and there fail to report to the supervision officer as directed for the month of March 2025 in violation of condition number 5.
Are you plead to that true or not true?
Not true.
State?
May I call witness, Your Honor?
Well, I mean, are you gonna read the other violations?
Yes, I'm sorry.
No problem.
Okay. Violation condition number 1, on or about the 7th day of February 2025 in Harris County, Texas, the defendant, Joshua Mackay, committed the offense of assault in violation of condition number 1.
Are you plead to that true or not true?
Not true. Violation condition number 15FF. On or about the 31st day of January 2025 in Harris County, Texas, the defendant, Joshua Mackay, did then and there fail to register for, attend an outpatient treatment program in violation of condition number 15FF.
Are you plead to that true or not true?
Not true. State will waive the other violation, Your Honor.
Any objection to the waiver of 10D?
No.
All right, state, you may call your witness.
Yes, Your Honor. At this time, state would call Miss Jessica Fuentes.
So could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Jessica Fuentes.
All right, state, you may proceed.
Thank you. Good morning, Ms. Fuentes. How are you currently employed?
I'm employed with Bear County CSCD,
And what does CSCD stand for?
Community Supervision and Corrections Department.
And what are some of your normal duties and responsibilities? Oh, excuse me, strike that question. What is your current job title with them?
It is Assistant Probation Officer.
Okay, what are some of your normal duties and responsibilities in that position?
I supervise cases that transfer out of state and out of county. So most of my contact is with states and counties.
Okay. During the course of your work in that position, did you have an occasion to come into contact with a case involving Mr. Joshua Mackay?
Yes.
How did you come into contact with that case?
The case was assigned to me in July of 2020.
Okay, what happened when the case was assigned to you in July of 2020?
He was on supervision with Harris County.
Okay, and once you became aware that he was under supervision in Harris County, what did you do at that point?
Notified Harris County that I was the new assigned officer.
Okay, so from that point in time, did you have any further interaction or was all his supervision from that point with Harris County?
Everything from that point was from Harris County.
Okay, did the probation officer in Harris County check in with you every now and then? Regarding this case specifically?
They sent me a report in, I believe, January.
What happened after you received that report?
I was taking note that he has.
We object to hearsay, Judge.
Sustain.
Without saying specifically like that, what was your involvement after you received that?
I was notified of his progress.
Okay, and were you notified of any type of successful completion of his probation from Harris County?
No.
I'm gonna object to hearsay again, Judge.
All right, that'll be sustained.
To your knowledge, has Mr. Mackay successfully completed, in your review of your own case file, his probation?
Object to hearsay.
Sustained.
She can testify about her own review of her own case file, Your Honor.
The objection will be sustained.
To your knowledge, is Mr. Mackay still currently on probation?
Yes.
Okay. To your knowledge, does he have conditions that remain outstanding?
Yes.
Object to hearsay.
That'll be overruled.
To your knowledge, what are some of the conditions that he has outstanding?
Object to hearsay, Judge. She's testifying from her knowledge from a document, not an evidence.
If you all make your legal objections, I'll respond to
Sure.
the legal objection. Your objection is the hearsay.
Hearsay, lack of personal knowledge.
All right, that will be sustained.
In your general course of working in your current position, are probationers required to check in regularly with the probation department?
Not with Bear County.
Not
You
with-
mean, do you mean with the,
Not, no, I'm not talking about this case anymore. I'm talking about in general. And to your knowledge, in your current position and in your experience as a probation officer of Bear County, is one thing that all probationers have to do is to check in regularly.
yes,
Okay. Your knowledge, did Joshua Mackay ever check in with you regularly?
Object to hearsay.
That'll be overruled with regards to whether or not he checked in with her.
Did he ever check in with you regularly?
no,
Was he required to check in with you regularly?
no,
At any point in time after his probation from Harris County stopped being monitored, was he required to check in with you?
Yes.
When was he required to check in with you?
as soon as this. case
An
was-
object to relevance, an object to relevance, it's not.
Overruled.
You may answer the question.
As soon as this case was returned to Bear County
To your knowledge, when was this case returned to Bear County?
in March of.
Object to hearsay.
Overruled.
And what was the response? I'm sorry?
March of 25.
What happens in March of 25 when the case was transferred back to Bear County?
He was to either report by calling or in person.
Did he ever report to you over the phone
No,
in March of 2025?
no,
Did he ever report to you in person in March of 2025?
no.
After he did not report to you for the month of March of 2025, what did you then do?
I submitted a supplemental MTR with failure to report for the month of March.
We have just a brief moment, Your Honor.
Yes.
Thank you. No further questions at this time. I'll pass the witness.
I have the court summary. You said your name is Ms. Fuentes? Okay. Did you bring the chronologicals for this case?
Not printed out.
Okay. Do you have any proof to the court that you, Mr. Mackey was advised to report to Bear County other than your testimony today?
No, I don't.
You have any proof that Mr. Mackey was notified that he was supposed to, his case was transferred back to Bear County? Do you have any proof of that?
I don't have proof of that.
That's what it's.
Just one question, if I may, Your Honor.
Yes.
Ms. Fuentes, you were asked by the defense about the Cronus that I guess you didn't bring with you. Would you have the ability to print that out at this time?
Yes.
Okay, and Your Honor, would Your Honor allow a minute for her to do so? That's my only question.
So any other questions of this witness?
Of this witness, no.
Any
No.
other questions? All right. So then that will leave, oh, sorry, you may be excused.
Okay.
That will leave the witness from Harris County. But since the court has received testimony on violation of condition number 5, does anyone wish to argue with regards to whether that is true or not true, or what the evidence showed?
I can make an argument, and then I guess defense can make his argument, if that's okay.
Yes.
Yes, Your Honor. At this time, as you know, the burden of proof at these types of hearings is by preponderance of evidence. You've heard testimony from the witness that while the defendant was not directly under her supervision, he was in Harris County being supervised out there. Once his case got transferred back to Bear County, he was required to check in with his Bear County probation officer, and he failed to do so. He never called. He never reported in person. He knows and should know throughout the 10 years that he's been on probation that that is one of his normal duty responsibilities as a probation officer, to check in with the probation officer. So upon him being notified that he was being transferred back to Bear County from Harris County, he should have checked in. He didn't check in, and we feel that that violation has been proven today, Your Honor.
All right, defend.
And we would ask also, I'm sorry to interrupt, the court to take judicial notice of the court file for this case.
Judge, they have to prove that he knew to report to Bear County. There's no testimony from this probation officer that he was advised that he was to report to Bear County, or that his probation was transferred back from Bear County. So they haven't proven that allegation based upon the testimony of their own officer.
All right. The court is gonna find violation of
Can I-
condition,
Yeah, sorry.
condition number 5 true. The court will await the witness from Harris County, if the witness from Harris County is able to appear to hear any testimony, if there is any testimony with regards to violations 1 and 15 FF.
Okay. I want to recall, I want to keep Ms. Fuentes subject to recall.
All right, Ms. Fuentes, you're subject for recall. Somebody needs you back here this afternoon. All right, is there anything? And is she allowed to appear by Zoom or you want her
No,
in person?
she's got to be here.
All right, so they're requesting that you be in person. All right,
Will the court withhold their finding as to condition number 5 until both sides have had an opportunity to present its case?
the court has found violation of condition number 5 true. If for some reason there is a testimony that is presented that causes the court to reconsider based upon any other evidence, the court will of course reconsider.
Okay.
All right,
Thank you.
thank you.
What time did you say?
Probably 4.
Okay.
So this is a discovery issue. What is the outstanding discovery?
CPS would say they have now, but they haven't given me a copy. They're working on giving me a copy. I'm sorry.
Yes.
My understanding from Miss Ashley. But we're still missing the MDTs. We're still missing the text messages sent on this case, on this particular occasion, Judge. My understanding.
And when will you have those for counsel?
Your Honor, I have put out my request. I have put out follow-up requests. At this point, I don't know what else I can do. I obviously don't have them in my possession.
All right, so what I'm gonna do is I'm recalling this for November. And anyone who is the person or agency that has custody of these, they need to be subpoenaed to come in and explain why they're not being brought. So Ms. Ferguson, if you can recall this for discovery, the beginning of November, please.
Yes, ma'am, I think it's November 6th.
All right, so November 6th and state, you need to have witnesses present and subpoena.
One other thing, Judge, there's a conversation between the complainant and Officer Martin at approximately 12:40 on the date of allegation. We want to know if there's a body worn camera recording of it being house.
I will put out the request.
All right, thank you.
Thank you, Judge.
You're welcome.
November what again, Judge?
November 6th.
Thank you, Judge. Have a great day.
Right, and state, do you have any objections to the defendant appearing by Zoom? All right, thank you. Fabian Singh. All right, where are we on discovery?
I'm fine with discovery, Judge. I'm gonna be filing a motion to suppress.
Okay. Was an offer tendered?
No, the state is needing to look at videos.
All right, Norma,
Yes, ma'am.
if you want to have your motion to suppress heard, give me a date in November for a motion to, I'm sorry, in December for a motion to suppress.
Yes, ma'am. Thank you.
And is it dispositive?
Most likely.
All right,
December 8th.
all right, December 8th. Everyone make sure witnesses are here.
Thank you, Judge. May we be excused then?
Once you sign the reset form.
Yes, ma'am.
All right, thank you. So, yes.
Yes, Your Honor. Just a quick background. So Ms. Reese is set today for compliance based upon the initial order of the court for DDRF, which she does not qualify for. I believe a motion to revoke probation has been entered as of today.
Yes.
And in speaking with my client, I believe that there may be some mental health concerns that are interfering with me being able to represent her and her understanding the nature of the proceedings, Judge.
So would you request a competency evaluation?
Yes, Judge, I'm requesting a competency evaluation. I can do that motion this afternoon,
Okay.
Your Honor, just to get it done as soon as possible, but I believe one would be needed in this case.
All right, Norman, recall this late December.
Yes, ma'am, I think December 18th.
All right, we'll come back on December 18th. That's to see where the evaluation is on the competency. I'll ask that the competency evaluation be expedited, but there is a shortage of doctors, so we'll do the best we can, okay? All right, thank you so much.
Thank you, Your Honor.
Thank you. Apollo Eckert. Court is calling 2025 CR 009153 State versus Apollo Eckert. Could I have parties announced?
Ted Wood representing Mr. Eckert.
Are there any applications?
No, Judge.
All right, Mr. Eckert, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
We are with the enhancements, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I have, Judge.
Court will
Now,
fi-
I haven't not received, I have not reviewed any videos that I may have received with him, Judge.
All right. Any objection to your counsel proceeding without reviewing the videos?
No.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with an unauthorized use of a vehicle. If the state proves the enhancement allegation, the range of punishment will be anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Judge, and just for the court's edification, he understands that he's given him up for only this proceeding.
Yes. All right, and do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Eckert, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? I'm sorry. Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, denied re-entry, and denied naturalization?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $2,000 fine, and there's to be no contact with Amanda Price. Did you understand it to be the plea?
Yes.
Defense is at the plea.
Judge, it is. We're asking for the time and money to run concurrent, and we're asking for any sort of back time that he may have accrued to be applied against his sentence.
State is at the plea.
That is your honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
Did you sign it in both places?
Yes.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Judge.
Then to the offenses charged, how do you plead?
No contest.
To the enhancements, how do you plead? True or not true?
True.
State any evidence.
State offers into evidence States Exhibit 1 with its attachments.
No objections, Judge.
Did you state your excuse? Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find the enhancements true based upon your plea are true and based upon States Exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, I'm just asking that he be have the 3-year sentence imposed, and he get credit for any sort of back time and money to run concurrent.
All right, the court will sentence you to 3 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money to run concurrently, and there's to be no contact with Amanda Price. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it, and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. If you don't change your ways, you're gonna end up in prison for the rest of your life. And if you're getting close to the point of being a habitual with state jail felonies, it's 2 to 20. Do you understand? All right, good luck to you. Hello, Mr. Johnson. What happened to your head?
Fell off the bunk.
All right, so what are we here for today?
Judge, I'm asking for a reset in this matter. I've had 6 days with the discovery, which is voluminous. And moreover, the state has just now given us an offer, which I've advised my client not to take. And we're going to have to do some more discussion and discovery in this case. So I'm asking for a reset, Judge.
All right, Ms. Ferguson. I need a 30-day reset, and this will be for a plea deadline date.
November 12th?
That's fine.
All right, so we'll be back on November 12th. On that day, you need to let me know whether or not you reached an agreement. If you have not, then your next setting is going to be a jury trial. All right, thank you.
Thank you, Your Honor.
You're welcome. Yes. Michael Sewell.
So since I discovered I have curly hair, I have taken an interest in curl pattern
See, let me
and
just tell you,
products.
we are saving Bashan, right?
Well, it sounds too late. Well, not her aunt though. The products make all the difference for me.
It does, it does. And you know, people who have curly hair don't want curly hair. People who have straight hair want curly hair.
Yes.
I just decided in my time on the planet, let it do.
Let it do. Yes, I understand that.
All right, the court is calling 2025 CR 007326 State versus Michael David Sewell. Can I have parties announced?
Lauren Espinosa for the state.
Lauren left in for Mr. Sewell.
And are you Mr. Sewell?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
We did, Your Honor.
The court will find that the state is in compliance with discovery. All right. And is there any applications?
No applications.
All right. Mr. Sewell, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are we proceeding on the indictment as presented?
No, Your Honor, if you would allow, the state would move to orally amend the indictment. It is alleged as the defendant's name is David Michael Sewell, but I believe his proper order is Michael David.
Any objections?
No objections to that. That's correct.
Mr. Sewell?
Yes, ma'am.
All right. We also need to, how do you spell your last name?
SEWELL.
All right.
So we may need it. for-
Then also, Your Honor, may we add another after the W in the last name?
No objections.
All right. Any objection to the court changing the name in the paperwork?
No, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yeah. Yeah.
Yes.
Yeah.
Yes?
Yes, ma'am. Yes, ma'am.
Okay.
I was thinking, I thought I went no to contender.
She hasn't asked you.
Okay.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes.
Did you understand by entering this plea, you're giving up those rights?
Yes.
And did you intend to do that and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Sewell, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No,
Are you satisfied with where you've been represented?
yes, ma'am.
Are you a U.S. citizen?
Yes.
Oh, I am so sorry. I'm not supposed to ask you whether or not you're a citizen. Did you understand by entering into this plea? If the court follows your agreement, if you are not a U.S. citizen, you will be deported, denied naturalization and re-entry into the United States. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 60 days in the Bexar County Jail under 1244, and there's $1,000 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Yes, Your Honor. State offer states exhibit 1 in all attachments.
No objections, Your
All
Honor.
right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just asked the court follow the plea agreement.
All right. So the court will find you guilty. The court will sentence you to 60 days in the Bexar County Jail under 1244. There's $1,000 fine, time and money will run concurrently. And the court will give you credit for any time served. Is there anything else with regards to sentencing?
No, Your Honor.
I'll question your $1,000 fine. How long was that?
The money and fine run together.
Okay.
All right. Did you have questions or not?
No, I'm okay.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to the attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. It's obvious that you have a drug problem, right? If you do not solve that problem, 1 or 2 things are going to end up happening. First thing, you're going to continue to get arrested, and you're going to end up spending a majority of your life in jail or either in prison. Or number 2, you're going to end up getting a hold of some bad drugs, or who knows, maybe the drugs are just fine. But that one time, there may be some issues. And the last time you use may be the last time you use, and then somebody's going to have to identify your body. Do you understand?
Yes.
Now, when you're released from the Bexar County Jail, if you cannot find a place that can help you with sober living or help you with any drug issues you may have, if I'm still here, you come back here and I'll pick up the phone and call somebody to help you. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you.
May we be excused?
Yes.
Thank you. Nice seeing
Have a good
you.
one. All right, Sergio Martinez.
Hello, Your Honor.
Hello, how are you doing?
Doing wonderful. Thank
Yeah.
you. It's good to see you.
You too. Let me see, what do I have here? All right, so where are we on discovery?
On the motion to revoke, Your Honor,
Oh, this is is this the motion to revoke?
it's maybe 3 new cases that all arise from the same incident.
Mhm.
And those are alleged on an amended motion to revoke of a habitation case that he's on for. What we would like to do is recall it for a disposition on Monday,
Okay.
and it should work out on that day.
Oh, I don't need it now. Thank you. All right, so we're gonna come back on October 13th. All right, thank you.
Thank you, Your Honor.
You're welcome. You're ready?
Yes.
Yes,
Michael Mora, Judge, you appointed me this morning?
yes. If you'll come forward. Hello. All right, so this is the new attorney who's been appointed to represent you. The previous attorney was not on the first degree will, so that's why you have this new attorney.
Okay.
So were you able to exchange information with him? Contact information? All right. So are you asking for 30 days?
Please, Judge.
All right, I need a reset for 30 days. November 12th. All right, we'll set it for November 12th for discovery. That's just to make sure that your attorney has all of the information that he's entitled to have. And then state on that date, you need to be prepared to tender an offer.
Yes, ma'am.
All right, once you sign the reset form, you excuse. Thank you for dressing appropriately for work.
Thank you, Judge.
Hi. Yes, you guys made it back?
Yes, I got some information. Okay.
Good afternoon.
How are you?
Hi.
We're gonna go ahead and take them.
Help me, Obi-Wan Kenobi, you're my only hope. Oh,
So Daniel took a look at it. He talked to me a little bit too. Unfortunately, he's still caught up with
yes.
whatever he's doing. But he texted to me, he goes, take them, we're good to go.
All right, Ms. Vasquez, who do you have? Isaac Wilson. If you'll come down, please. All right, what is happening with this case?
Can we get to Ken?
1 second.
You want me to go first, Judge?
Yes.
So as of the last setting, we were waiting on a video from Via. As of this morning, state did not have it, but during lunch hour, we secured it. So I have a copy for defense counsel that I can tender to the fourth floor window.
Okay. All right, and the
Judge, can you
via,
hear me?
The Via
yes.
survey.
All right, the via,
Okay.
via surveillance is the only thing that you're
Yes.
waiting on? And were you able to tender an offer?
Yes.
Okay.
I am so sorry, Judge. I missed everything. My audio wasn't working.
All right, the state has the via surveillance. They'll have it at the window available for you.
Oh, okay. Yes, that was the issue this morning. They did not have that.
Okay. So your attorney was just waiting for that to you. All right, Ms. Ferguson, if you're, how old are you, sir?
36.
All right, Ms. Ferguson, if you'll recall this in 3 weeks for plea deadline date, please.
Judge, if I could request a reduction on bond while he's pending the next hearing.
All right, has a motion been filed?
I will file it right now, Judge.
All right, once you file the motion, just ask Ms. Ferguson to put it on the docket and I'll hear it.
Okay, thank you.
All right, October 30th is going to be your plea deadline date. At that time, you'll need to let the court know whether or not you've reached an agreement. If you have not reached an agreement, your next setting will be a jury trial date.
Okay.
All right, thank you. And your attorney
Thank
will
you, Judge.
file for bond reduction and we'll have you brought back over.
All right,
All right, thank you.
thank you.
Thank you, counsel.
Thank you. Thank you, Judge.
All right, the court is calling 2023 CR 0469 State versus Timothy Hernandez. Can I have parties announced?
Lauren Espinosa for the state.
Adam Ford for the defendant, Your Honor.
And are you Timothy Hernandez?
Yes, ma'am.
All right, defense has filed a motion to set bond, and is this a motion to revoke as well?
No, Your Honor, there's only a motion to set a bond.
No, I mean, is he on probation?
Yes, Your Honor, is an MTR, Your Honor.
All right, can I see the MTR, please? And it's on Timothy Hernandez. Thank you. Thank you so much. All right, so the defendant is on deferred adjudication, so he's entitled to a bond. And have you all discussed the motion to revoke?
I do not believe so.
No, Your
All
Honor.
right, so if y'all would discuss that and then come back up and I'll take up your motion to set bond.
Yes, Your Honor, thank you, Your
All
Honor.
right, thank you. All right, so the motion to revoke, is that going to end up being contested?
Yes, Your Honor.
It's that next Thursday? Yeah, the NPR was. All right, thank you.
Your Honor, I'm not the attorney record for the MTR, I'm the new number one. I'm only the attorney record for the
The motion to revoke?
Motion to revoke.
All right, so here's the thing. This is your attorney for the motion to revoke. According to the allegations in the motion to revoke, there's only one allegation in the motion to revoke, and that's a new number one. So this attorney is going to be handling that motion to revoke. And since it's contested, it's going to be contested with regards to the new number one. Do you understand? All right. So you're on deferred adjudication. Do you understand that? The state is alleging that you violated your deferred adjudication. And this number one, is that a misdemeanor or is that a felony? The allegation?
It's a state jail felony, Your Honor.
No, I mean the new number one within the motion.
Yes, state jail felony.
So is the charge?
So the charges of driving while intoxicated with a child under 15 alleged.
All right, so what that means is whether he represents you on the new number one or not, that's not an issue for the court because you're on deferred adjudication. He is stating that he is your attorney on the deferred adjudication, so he handles that entire motion. Do you understand? And you're set for a contested hearing on Thursday. Do you understand?
Yes, ma'am.
All right, so with regards to the motion to set bond, have you all come to an agreement?
Yes, Your Honor, I believe our agreement is for $10,000 bond.
That's correct, Your Honor.
All right, Mr. Hernandez, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Timothy Hernandez.
All right. In the past, have you ever had any type of mental health issues?
No.
Have you ever been on any type of medication for mental health issues?
Not terribly, no.
All right, so the person who's in the back, let me ask you something. We're off the record. Have you been sworn in to testify? So your answers are not his answers. Do you understand? Okay.
Judge, she's here for somebody else in the box.
Well,
No, she's a wife.
She's. My next question for you is, have you ever used any type of drugs in the past?
Yeah,
And what would that be?
just marijuana.
All right, this is what the court is gonna do. The court is gonna set your bond at $10,000. There's to be no driving. Any other conditions requested?
Random UAs, or I'm sorry, he said, I'm sorry.
Yeah, okay. And there's to be 15 sober meetings in 15 days. All right, is there anything else?
No, Your Honor.
All right, we'll see you on Thursday, and Thursday will be your contested hearing.
All right, thank you.
Thank you, Your Honor. May I speak, Your Honor?
Norma, he needs a reset. Norma, he needs a reset. Thank you.
Thank you, Your Honor.
You're welcome. When do you think he will be
I can
official?
get him in next week. I just need to coordinate with Malik and he just needs to be on probation.
Okay,
So that's the only two things I'm looking at.
all right, so let me see the file on Hatch, please. Malik Patch. Oh, you're welcome. You know, I'm shed tears. All right, so is he, then they're saying that he needs to be placed on probation? So,
Yeah, I'm not quite
so,
sure what.
let's do that. And if we get that done today, they'll be able to have him in the program next week. So if you will state, are you on Hatch? All right, so my understanding, he's being accepted into Veterans Treatment Court. And they're willing to get him into the program next week. But we need to go ahead and do sentencing today.
Okay.
So if you could draw up the paperwork and then we'll take care of it today. And then I'll put as part of the orders, my not general, but specific conditions to him And one of those conditions will be a referral to Veterans Treatment Court. And if he doesn't show up, so
He sounds like we just talked, he sounds like he's ready to go, so
Okay.
we'll get it
Okay,
going.
so just go over the paperwork and then Ms. Abrams will give me the referral for you all. And
Perfect.
we'll go from there.
I'll write it out.
Of course. All right, Audrey Jessica Bash. Thank you. Hello.
Hello.
Court is calling 2025 CR 0089991 State versus Audrey Jessica Bash. Can I have parties announced for the record?
Joseph Stateson for Audrey Bash, and Your Honor, if I may, we are here for her to enter a plea on the motion to revoke probation, and there's a number one offense that she intends to plead on. And just so the court's aware, we're going to ask for a PSI and for sentencing to be the same day as the MTR PSI, the same date to handle both sentencing.
Yes. All right, counsel, in this cause number, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
And your Ms. Bash? Did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes.
And I also have an application for community supervision. Did you review that as well?
Yes, I did.
Did you review the true bill of indictment with your attorney?
Yes,
Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Bash, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did.
You're charged with unlawfully carrying a weapon with a felony conviction. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
I did.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 6 years in the prison and up to Did you understand? I'm reading the plea bargain agreement. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
We've discussed that. Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Bash, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yeah.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied re-entry, and denied naturalization. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication or community supervision. This will run concurrent with 2024 CR 2272. The state will take in consideration 2025 CR 0089992. Did you understand that to be the plea?
I do.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you're requesting a PSI and TAP evaluation, that
Yes,
will be
Your Honor.
12 weeks.
We're hoping that something could be scheduled sooner, and if something else drops off, if an inmate is sick in the hospital and it bumps her up, we would hope to come back before on an earlier setting.
All right.
And she did have a TAP evaluation earlier, but I don't know if that's been expired or not.
Okay. All right, Norma, I need a date, PSI and TAP evaluation. Let's put it down for 6 weeks. Let's see what we can do. All right, we'll say yes.
Hopefully November 20th and not delayed.
All right.
Thank you, Judge.
You're welcome. So we're going to move on to 2024 CR 2272. Did you have a chance to review the motion to revoke community supervision with your attorney? Did you understand it? Are you the same Audrey Bash who was placed on community supervision in 2024 CR 2272 for the offense of possession of a controlled substance penalty group 1, 1 to 4 grams on September 19, 2024 for a period of 5 years? Is that you? All right, state.
Violated condition number 1, on or about the 5th day of May, 2025 in Bexar County, Texas, the defendant Audrey J. Bash committed the offense of unlawful carrying of a weapon with felony conviction in violation of condition number 1.
How do you plead to that? True or not true?
True.
State.
We would waive all others.
Any objections to the waivers?
None.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, sentence you up to 10 years in the prison?
I do.
Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. This will be recalled on November 20th. All right, is there anything else?
Nothing further at this time.
All right, thank you.
Thank you.
Thank you, Judge.
You're welcome.
And off the record, I do have certificates that she may be taking some more classes, not to include in the file, but on November 20th, I intend to just have you review those.
Sure. All right, thank you. Yes. Counsel, Leila, yes.
Judge, Mr. Ross has the MTR as a result of this new case. And so we sent it over to today to see if he got indicted. He got indicted. And so we're just asking for the quickest trial date possible. If you need to send us down to impact, we're okay with that. Mr. Ross is just indicating that he wants to have his day in court and get this case resolved really quickly. So whatever way we can get that done, we'd appreciate it.
What, do you want to hear the motion to revoke?
Oh, well, no, we wanted it to carry with trial, just trying to get a really quick trial date. We can go to trial within, say, 2 to 3 weeks, we'd be good with that. If that's possible. I don't know.
That's probably not going to be possible because we have murder cases that have been set, capital murder cases that have been set. State, when do you all anticipate being ready? I could place it on the date with other cases and see what happens to those other cases, but they already have murder cases set.
Well, any accommodations the court can make, we're open to. And again, if you want to kick us out the impact court, we're good with that. Whatever.
We don't have,
We don't have that. Okay.
not with a jury trial.
Yeah, whatever the court thinks is, can get us there, we're open to.
If y'all want to confer with Ms. Ferguson, but I will tell you this, the motion to revoke will be heard quickly.
Okay.
So. And are you all, because today is the contested hearing for the motion to revoke. Are you all ready on that?
So we were prepared to prove up the technicals,
Okay.
but regarding the probation officer, we were waiting to see what was gonna happen to see if she comes down, so I kind of been. Also, I guess, in theory I was, but the probation officer is not here, so no.
Okay, so this is on Ross' case, the probation officer is out of county?
Well, she's not out of county, she's in town, but I haven't told her to come down there because it's in an office that takes an hour or so to get here.
Okay. So this is what we'll do. Norma,
Yes,
set this hearing for contested. Can we do it the week of October 20th? because we have a jury trial next week, correct? Yes. All right, so if we can do it for the week of October 20th. And are we able to do it? Would Monday be better?
Yeah, Monday would be better.
All right,
I have
October,
I have a trial date that day in Hayes County,
okay.
and so I don't think he's gonna show up, but if he
Okay.
does.
All right, Ms. Ferguson, are we able to do it October 27th?
Thank you.
Okay, so we'll do, Mr. Ross, your hearing will be set for a contested hearing, agreed date for October 27th. And counsel, do you want the probation officer here in person, or are you okay for them to appear by Zoom?
Well, I was going, the one thing I wanted to point out was the technicals are stuff that, just for context, like when you get violated, they just bring the whole kitchen sink, everything you've ever done. But most of that stuff he was still in the progress of doing is really just a new number one. I think it was like a parenting class or something like that. Maybe he didn't pay. He didn't. I think he failed to report one time. I think he was actually in jail when that happened because he got arrested. So Mr. Ross is saying he would like to speak with the court.
Okay, so just 1 second. So that's the contested hearing is gonna be set for October 27th. And then Norma, I need a jury trial date on that new case in state and defense, if you'll confer.
We'll take whatever you want. We'll take it.
Okay. All right, so December 9th. And Mr. Ross, there was something you wanted to say? Oh, no. See, here's the thing. You're not allowed to talk about what you've completed until we actually have a hearing on it. Then those are things that for your attorney to bring up. Oh, no problem.
We'll be back.
All right, thank you. And on the new case, if you all can sign an acknowledgement of discovery for the court. All right, Malik Hatch. Court is calling 2025 CR 002556. State versus Malik Hatch. Can I have parties announced?
Christine Dolphin Hernandez for the defense.
And then we do remember to impact this case.
All right. And are you Mr. Hatch? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hatch, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Hatch, did you review the court admonishments with your attorney? Did you understand it
Yes, ma'am.
and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
absolutely, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Absolutely.
Mr. Hatch, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Absolutely.
If you're not a U.S. citizen by entering this plea, you will be deported denied naturalization and re-entry into the United States. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at $1,000 fine. If the court finds that a weapon was involved, then the court will enter in an affirmative finding of a deadly weapon. The state recommends deferred adjudication. This will run concurrent with 2024 CC 737673. There's to be restitution of $1,407.24 to the complainant in 2024 CC 737673. Did you understand that to be your plea?
Yes, sir.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
Your Honor.
Any pretrial motions that have been heard and ruled upon?
No, Your Honor. Sorry.
No problem. Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. There'll be a TAP evaluation, 200 hours of community service restitution, and no contact with the complainant. Did you understand that? Those are recommendations from the state, and the court does not have to follow those recommendations.
Yes, sir. I have a question.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State offers states exhibit 1 and all attachments.
Any objection?
No objection, Your Honor.
Mr. Hatch, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Since Mr. Hatch has been out on bond, Your Honor, he has taken full responsibility of his own actions. He is seeking treatment through the VA hospital. And at this time, we were also seeking entry into the Veterans Treatment Court program. He has been evaluated, as you know, Your Honor, and preliminarily accepted into that program. He is looking forward to earning his second chance, Your Honor. He understands that his actions were uncalled for on that day, but that he has some health issues that he's been addressing to make sure that nothing like that happens again.
All right, State, have you had a chance to speak with the complainants?
Yes, Your Honor. They're in different state.
Okay. All right, I tell people this all the time. Accidents are just accidents. That's why people have insurance. It shouldn't get to the point where people are fighting after an accident occurred. It's everybody gets out of the vehicle, everybody exchanges insurance information and, their driver's license. And everything is not an accident where people are in the middle of the road impeding traffic. You're not going to get millions of dollars, but when people are involved in accidents, you can't get angry at other people. It's just not done.
Yes, sir.
Right? And I understand that you were in the military.
Yes, sir.
Yes, sir.
And what branch?
Armory.
Okay. All right, this is what the court is going to do. There's $1,000 fine. That will be probated. Are you currently employed or no? Is that due to health issues?
It's due to him seeking treatment and having an aggressive treatment schedule, but also this case has kind of held him back. He's also in school right now, Your Honor, and will be finishing his business management program at the end of the year. January. Yes.
Okay.
I know that the complainant is present and would like to say some words today, Your Honor, and I don't want to overstep. The aggression was definitely on both sides that day. Mr. Hatch felt threatened and he felt triggered. Not saying he was rational, but he felt triggered by saying words that were used that were racially motivated, and he should have reacted differently, but the complainant is not completely innocent in this.
All right, there's $1,000 fine. It'll be probated. You to provide proof of employment or full-time enrollment in school within 45 days. There's to be no employment as a home healthcare provider with minors. Regular reporting by Zoom or in person, regular random UAs. This will run concurrent with 2024 CC 737673. There's to be restitution in 2024 CC 737673. And is that case being taken in consideration or no?
No, Your Honor, they are to, or yes.
All right, so I know they're going to ask for restitution there. There will not be double restitution, but the total amount of restitution will be $1,407.24. So if he pays it in misdemeanor court, then
It'll count for.
oh, Bashan is like, no. So how should we do this, Miss Abram?
Either on this or on that one. It needs to be on either one. We would prefer to be on this one.
All right, so then there will be no restitution entered under cause number 2024 CC 737673. However, there is to be restitution in the amount of $1,407.24 to Michelle Morales. There's an affirmative finding of deadly weapon. There's to be no contact with Michael Oliver and Michelle Morales. There's to be 200 hours of community service restitution, 6 years deferred adjudication, and referral to referral to Veterans Treatment Court. And it's the court's understanding that he has been accepted in Veterans Treatment Court. Is there anything else that you need to be successful? Probation, is there anything else?
Judge, I can't mention no visits.
Field visits 1 time per month for 6 months. And of course, probation, once he's transferred to Veterans Treatment Court, Veterans Treatment Court will set your conditions for you. So for example, I'm telling you that you need to be employed or full-time enrollment in school within 45 days. Veterans Treatment Court will evaluate you. And if Veteran Treatment Court does not think that's appropriate, then they will change that.
Yes, sir.
So the field visits 1 time per month for 6 months, that's what I'm ordering. But once your probation is transferred to Veterans Treatment Court, Veterans Treatment Court will handle all of your conditions. The only time you'll come back to this court is if they are saying that you're no longer appropriate for the program and they are asking that you be removed from the program, and they'll do that in the form of a motion to revoke. Do you understand?
Yes, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. I cannot stress to you how this could have turned out to be so differently. I don't know why people don't have patience anymore. I don't know why people speak to each other in such a negative way.
Yes, sir.
When accidents happen, they're called accidents for a reason, and that's why people have insurance.
Yes, sir.
All right?
Yes.
All right, my understanding, there's a victim impact?
Yes, sir.
Here's the motion. After looking at the allegations in the case that was submitted, as well as her conditions from being originally placed on probation, I think that it would be in Ms. Carrizales' best interest to get a little progress going on her probation. So we're in agreement to alter and amend to add MRT as well as for her to accomplish a parenting class within 60 days.
Okay.
That is correct.
And do y'all know, has she provided probation with drivers like a valid license and insurance?
To that, I'm not sure, Judge. I don't believe at this time she has one that's in compliance. I think it may still be suspended. But I will definitely relate to her that she cannot be operating a motor vehicle unless she has that. And then when she does get that, to get that to probation.
Okay.
Because the UMV, I know that stemmed the new number one, which has since been dismissed. But I do understand the court's concern with her driving without a legitimate license.
And this is to complete parenting classes within 60 days?
Yes, she was originally placed on probation in 2021 and hasn't done anything. It's our understanding that she did go to TBC on a previous case, it kind of overlapped.
Okay.
So we're giving her a little credit for not being able to, but it has been a while, so we want to get her going.
All right. Thank you.
Thank you, Your Honor.
Yes. All right.
Give
thank
this to
you.
probation or the clerk? Your Honor?
Oh, just give it to probation.
Yeah.
All right. Are you all ready on Mackie? All right, we're back on the record in 2014 CR 2014 CR 5495 State versus Joshua Mackey. If I could have parties re-announce, please.
Defendant for the state of Texas. And Kelly Fiddle for Joshua Mackey.
All right, and this is a continuation of the hearing that was started this morning. State, any witnesses?
Fortunately, it's not having markers.
All right, defense, any witnesses?
Defense rest, Judge.
All right, the court has found violation of condition number 5 true. The court is going to find violation of condition number 1 not true. The court is going to find 15 FF not true. All right, any objection to the court's reviewing the court summary?
None from the state.
Can I see it?
And for the record, the court has not reviewed the court summary.
Can I remove the violation reports?
You'll have to speak with probation about it because that's their court summary.
I just don't, I have no problem with you speaking to the court summary, but not the violation reports, since they were not. Okay, that's right. No objection, Judge.
Oh,
so
You have your own? Sorry.
No, I don't.
oh, okay, then, yeah, that's,
Yes.
All right, so what portion are you all asking me not to read?
I didn't realize that the violation reports are already in the court's file that you,
Yes.
that's taken judicial notice of, so no objection, Judge.
Okay.
And if we could just have time for a brief argument after.
Yes. Oh, and counsel, I don't have a trial court certification.
We'll get you one, Judge.
Okay. Oh, do you want to grab that while I read this?
Sure.
And state defense and Mr. Mackey, I see that there's a condition of number 1 in here. I previously said that that condition is not true.
Yes, Your Honor.
So I'm not going to consider that because I found it not true. And it's the same, the mention of condition 15 FF. I've also found that not true.
Thank you, Judge. Judge, can I present this to the court?
Yes.
I'll have it marked if you need me to. The state has waived this condition 10D, but I just wanted to bring it to the court's attention that the restitution is paid in full.
So was the restitution 36,000 or was it 44,775?
It was, what he owed was the 4,000 number.
Okay.
The total was the 36. The 4,000 was paid.
All right, the court has reviewed the court summary and the court has reviewed the document that the defense asked the court to review. State, what are you requesting?
Your Honor, you've taken judicial notice of the entire court file. You're aware of the facts of this case, the egregious nature of them, involving shooting the victim through the head, the right temple, exiting out the left side of her face. Very well could have killed her. Thank God it didn't. Otherwise, we'd be here on a different charge. So given them the facts of the case, given that the defendant is on his second MTR since he had been placed on probation. And given the one true violation you found, Your Honor, State would ask for him to be revoked, adjudicated guilty, and sentenced to 10 years TDC.
All right, so as a part of your plea bargaining agreement that was entered into, the state was silent on your application. So I'll note that for the record.
Yes, Judge.
All right, defense, the state is asking for revocation. They're asking that your client be sentenced to 10 years in the prison. What are
Judge-
you requesting?
Judge, we're asking that you deny the MTR and terminate his probation. In regards to the facts of the original case, I believe I represented him at the time of his plea, and the complainant was okay with him getting probation. Judge Hilbig gave him probation, gave him jail time as a condition. In between when Mr. Mackey committed his offense and when he pled, Mr. Mackey was shot in the head and almost died. That affected his brain functioning. He had a TBI and went through competency and was competent to stand trial. In regards to this being a second MTR, the state waived the first MTR, so it's not really something that the court, we believe, should consider. And we asked the court to reconsider that true finding. And the reason we asked that, Judge, is if you review those conditions of probation that are in the court's file, I've never had a contested MTR in which the state didn't either have the probation officer who read him those conditions testify that he signed those conditions, or number two, have someone, a fingerprint examiner, come in and testify that that thumbprint matches Mr. Mackey's thumbprint. The state has failed to prove that Mr. Mackey signed those conditions of probation, that he had knowledge of those conditions of probation, and therefore nothing could be found true because they haven't proved that he is the person who signed these conditions. In addition, what I testified to earlier and what Ms. Fuentes testified to was that there was no testimony or evidence presented by the state that Mr. Mackey knew to report to probation. There's nothing in those conditions that say, if this case gets transferred back to Bexar County, you must report to Bexar County probation. All it says is condition number 5 is report as directed to Bexar County. Well, we know that wasn't an actual condition of Mr. Mackey because he lived in Harris County. He was reporting to Harris County this entire time. Now, if the court still finds that it's true that he violated condition number 5, the court can do so, and we respect that. But we ask the court to review the totality of the case and that they have proven that he failed to report for 1 month out of 120 months. That's 0.8% of the time that they allege that he failed to report. And we ask that you consider what they've alleged and what they've proven and deny the MTR and release Mr. Mackey from this probation.
All right, the court is, as previously stated, the court is finding 5 true, 1 not true, 15 FF not true. The court will find the defendant guilty, grant the motion, revoke. There's an affirmative finding of deadly weapon. And the clerk printed it out. I couldn't find it either. I'm trying to see because I'm not the one who did the plea. The previous.
Are you looking for the plea bargain number?
I have the plea bargain, but there are no mention of no contact, or I'm sorry, there are no mentions of any no contact orders. So. Sorry, counsel, do you have the trial court certification?
I haven't had him sign it yet, Judge. I need to explain to him.
Yes, please. All right, there should be no contact. There's to be no residing in any households with minors. And the court will sentence you to 6 years in the prison. give you credit for any time served. Is there anything else?
We asked for findings in fact and conclusions of law.
And have you gone over the trial court certification?
I have not, because
All right, if you'll go,
he needs time to understand it.
yes, okay. And then just come back and I'll finish. Thank you. Mr. Mackey? You have a limited, I'm sorry, did you review the trial court certification of defendants' rights to appeal with your attorney? All right, did you understand it and sign it? I have to say yes or no for the record.
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what that is, you need to speak to the attorney. Do you understand? All right, good luck to you.
Thank you.
You're welcome. All right, are you all ready on Naomi Abba? Court is calling 2025 CR 009075 State versus Naomi Virginia Alba. Can I have parties announced?
Lauren Espinoza for the state.
Martin Getter, attorney for Naomi Alba.
And are you Miss Alba?
Yes, ma'am.
And defense, there was something you wanted to be placed on the record?
Yes, Your Honor, if I may ask for a few questions.
Yes.
Ms. Alba, are you the same Naomi Alba that's currently on a 3-year parole?
Yes, sir.
And you understand that by entering a plea today, that could result in your parole being revoked?
Yes, sir.
Knowing that your parole could be revoked, do you still wish to enter a plea today on this case?
Yes, sir.
No other question.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Alba, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the repeater enhancement.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with possession of a deadly weapon in a penal institution as a 3rd-degree felony? The range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Alba, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
By entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry into the United States. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. State opposes your application for deferred adjudication. State recommends community supervision. They will take in consideration 2025 CC 009259. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead?
No contest.
State, any evidence?
Yes, Your Honor, state offers states exhibit 1 and all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, the court is going to find that there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Do you all wish to proceed or do you want a PSI? If you want a PSI, it's going to be about approximately probably 12 weeks.
Okay. Well, then we want to go forward. I don't know if you want to wait that long.
All right, then you're waiving PSI?
We'll wait PSI. Your Honor.
All right, the court will hear arguments against deferred.
Yes, Your Honor, state would urge that you deny the application for deferred based on criminal history. The most recent being an injury to an elderly person with bodily injury of January 9th, 2024, as well as multiple criminal trespasses, possession of marijuana, as well as evading arrest or detention. So that we don't see that she's fit for deferred at this time.
All right, and defense, your argument for deferred?
Your Honor, aside from the fact that my client accepts responsibility, I think there are some genuine issues here that make this different from the typical case of someone taking a deadly weapon into a penal institution. In this particular instance, what we have is that the officers brought her there, and then we have CERT officers taking her further into the facility. Yesterday, prosecutor was kind enough to help me get additional questions answered regarding the video inside the Sally Port and also inside the South Tower, because there's unfortunately not audio that's available, it's only video. But this is not a situation where she is a person who is intentionally trying to sneak a weapon into the facility. And in fact, she indicates that later on to the investigator from the sheriff's office when she was interviewed. Your Honor, this is, again, I have no problem asking for deferred adjudication in this particular case because if you look at the criminal history, it's all relatively minor. There is that one injury to elderly, and I will say that the knife that was seized was actually given to her from the person who was the subject of that previous injury to elderly case. She knows him, she's worked with him. He gave her that knife because he was concerned about her own safety because she walks quite a bit and she does so at night. And so again, this was something that was for her own protection. I just think that there's much to distinguish this from the typical case and that she does not pose a danger to the community and her relatively minor criminal history. I think all weigh in favor of her getting deferred adjudication, Your Honor.
All right, why didn't you just leave when he said he no longer wanted you there?
Ma'am, actually, he didn't tell me that himself. It was just the neighbor that actually I'm not sure the word, but he was kind of meddling into our business. I was there to cut the old man's toenails, as a matter of fact. And I had fallen asleep on the couch, and the neighbor came in and he was meddling in our business, and he just started yelling at me. And then instead of, yelling back at him, I just sat back down and I just kind of dozed off into my sleep. But the old
But
man,
no, they talked to the person there and he said he wanted you to leave and you wouldn't leave.
he never told me that, not once, ma'am.
Okay. So do you have any children?
Yes, ma'am.
And how old are they?
5 and 6 years old, ma'am.
And who do they stay with?
Their father.
When's the last time you had employment?
Well, I was self-employed, basically just working for that old man.
Okay. All right, this is what the court is going to do. The court is going to find you guilty. The court will sentence you to 5 years in the prison, suspended and probated for 5 years. There's a $1,500 fine that will be probated. Take in consideration 2025 CC 009259. There's to be no contact with Jurgen Smith. JUERGEN SHMIDT. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home healthcare provider or with minors, field visits 1 time per month until further notice, no unsupervised contact with minors, no residing in households with minors, 200 hours of community service restitution. The court will order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Probation, is there anything else?
No,
Is there anything else that you need from the court to be successful?
no, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? With your attorney, did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you.
You have a good day. God
Oh,
bless you.
thank you. God bless you too. You're welcome.
I like your joke earlier.
Okay.